Good morning. The hearing today is in the matter of CFI 005-2022 before Registrar Noor Hanadi and is being held by way of video conference. The claimants are represented by Nimble Legal Consulting FZE. Lead counsel is Justina Stewart. The defendant is represented by Curtis Mallet Prevoy, Colden Mosel LLP. Lead counsel is Sophia Hurst.
Thank you very much. Ms. Stewart, it's your client's application, so would you like to get us started? Just for the record, I confirm that I've read through the skeletons, I've read through the witness statements which were filed both in support of the application and then in response to the application by Ms. Burt on behalf of the defendant. I've got some preliminary views. I think the way we ought to proceed today is perhaps to nut out whether the request, the Part 19 request, was made appropriately. I think that's probably the first and overarching question, because I think I've seen in the submissions that there's been lots of back and forth as to whether a Part 19 request should be made before the exchange of witness evidence. And obviously the claimant says that, yes, it can be made at any time, and the defendant says, we haven't yet exchanged witness statements. So let's do that, and then we can get into a Part 19 request. So we can perhaps talk about that first, and then we can go into the specific requests, Ms. Stewart. I haven't seen too much on whether each and every request is obviously agreed to or not agreed to. I suspect Ms. Hurst's position would be that her client doesn't agree to any of the requests at this stage, and that's been essentially the nature of her skeleton. But I'll let you get started, and then we can make some directions.
As I understand this, indeed, nothing's agreed, I'm afraid. A couple of housekeeping things. We've had some pagination issues. We could stick to the master bundle and use that pagination. Hopefully it will work. The defendant has filed an additional bundle. You may have seen some correspondence about that. It runs to about 300 pages. I haven't had a chance to look at it. I don't know what's in there. We'll see what happens if Ms. Hurst refers to it or not.
So the bundle that I've read and the one that was made available to me was the one that was filed. Let's have a look. Now it's quite annoying going back and forth with this bundle because I can't unfortunately open up more than one bundle at a time, and now my computer refuses to cooperate. But it was the one I think that was filed by the defendant, which has on the tail end of it at tab Y, skeleton and authorities for hearing on 26 May. And the defendant then latched on its documents for application at tab X, and these were not agreed by the claimant. So I don't know if that's the same bundle that you're referring to, Ms. Stewart.
Well, the bundle I've been working from, and the one that was filed according to the deadline, was bundle W. So, and those were the references in my skeleton argument.
Now,
perhaps, shall I jump in there just to clarify?
Please.
I think that there's a practical problem and then there's a sort of detailed problem about what goes where. In terms of the separate, I'm using the digital system, and in terms of the separate application bundle, which I think has been named Bundle 6, neither I nor my instructing solicitors can access that. I think there's a technical problem with the system. So I'm going to have to work from the master bundle. I think the pagination is the same if we're just looking at tabs W, X and Y. But if bundle 6 is different, and if either of you are looking at bundle 6, I should just flag that I can't see that. So that's the practical problem. In terms of what's been filed, as I understand it, the direction was to file an agreed bundle by the 18th of May. The claimants sent us an index and asked for comments. We asked for additional documents to be included, and the claimants refused to include them. So what was filed was their bundle W, and we have additionally filed the documents that we had asked to be in the agreed bundle, which is tab X. Given that we're all having difficulties with bundles, I will do my best not to go to anything in tab X unless it's absolutely essential. but there's no suggestion. I think made by my learned friend that anything untoward has happened in us filing an additional bundle. It's just that those were documents that we'd asked for and that weren't put in the agreed bundle as requested.
Just to clarify, it was 10 minutes before the deadline we had that request. I don't want to get into satellite argument. We've got enough to get through. If anything is referred to in X, I will do my best, but understandably, I haven't had time to go through 300 pages. Right. So in terms
just quickly,
of
Ms. Stewart, I just want to identify that I had tried my very best to search for the requests that were made, and I could see that they were referenced in your skeleton and then cross-referenced in Ms. Hurst's skeleton.
Yeah.
They were referred to, I think, at W386 or thereabouts. And my version of the bundle does not match with that reference. So give me time, please, as you walk me through it to find the relevant document, because I still couldn't find the requests. I have not read through the 51 odd requests that your client has made.
there are 51, I think. Oh, well, there might be if you sub. Oh,
okay.
It's coming up on mine when I do W386.
And that's under tab 15, I think. So it's W15, is that right? Which is exhibit HGK2?
Yes, yeah.
Yeah, I don't have the same document. I've got something very different.
Could you, I think what might be happening is if at the top you could change to the master bundle, top left.
Let's have a look.
Master bundle 01.
Okay. Let's see if that changes things. I apologize, it's taking such a long time to load up on my screen. Yes, that does match now, but it didn't match before when I was referring to it under 1. Okay, so let's proceed. And at least now we're all on the same page, I hope.
Okay. Before I get into the law, just to give an overview, in essence, and just to recap, as you will have seen, Madam, the claimants, they were previously employed by the entertainer. They seek sums which they say are owed under a settlement agreement. The entertainer, it was a Techcom incorporated company. It was previously owned by Date Holdings Limited, which a Cayman company. And Date, in turn, was owned 50% by the defendant. Now, in 2018, she sold a significant proportion of her shares to a private equity firm called GFH. The defendant says that the claimant's not entitled to the sums claimed, and further that we should repay what's already been paid and also pay damages for losses in the value of her shares, which she says that we caused. Now, in broad terms, very broad terms, she founds her defence and counterclaim on a number of grounds, which we divide into breach of duties owed as directors of entertainer, breach of duties owed by the second claimant as a director of Date, the Cayman company, misrepresentation and breach of fiduciary duties. That's the broad parameters, the very, very broad parameters. The real issue here is that we don't understand in reality what she's saying, what exactly it is that we've done wrong, and why and how she alleges that this has in fact caused her any loss. A major part of this, her counterclaim obviously being the loss in business value. So the loss, she's saying, essentially there was a secret plot, we went behind her back and we somehow conspired to decrease the value of her shares, or there was some kind of conflict. The requests were made before, as you've identified, before the exchange of witness statements, so that we could prepare the witness statements. The alternative being to write long, rambling witness statements which didn't go to the real issues and which would just serve to escalate costs, waste the court's time, waste everybody's time and money. We did expect the request to be answered. I've never experienced such intransigence, but due now, we say, to the defendant's approach to the requests, we strongly suspect that she doesn't actually know the answers, which is not what we thought when we issued the requests, but that's increasingly the inference which we say should be drawn. And if that is the case, it's far better and in the overriding objective that we find out now. Going to the relevant law now. And we are, I think, rather far apart on the law, my learned friend and I. If I could take you to my skeleton argument beginning at 17, we should just go back to first principles here.
Beginning at 17.
Paragraph 17 of my skeleton argument.
Paragraph 17, yes, just bear with me, please. Sorry, Ms. Stewart. I'm finding it in amongst the many, many documents under this master tab.
It's right at the bottom at Y.
Got it. Thank you.
And forgive me for going back to first principles, but just to state what RDC 9.1 says, the court may, so there's a discretion, at any time order a party to clarify any matter which is in dispute, or give additional information in relation to any such matter. And then it goes on to say whether or not the matter is contained or referred to in a statement of case. And then we go on to 19.6, which says that the request should be concise and they should be strictly confined to matters which are reasonably necessary and proportionate to enable the first party to prepare his own case, so that would be our case in this instance, or to understand the case he has to meet. Going on a bit further, we've seen in the case of Georgia, the DIFC court, that basically RDC Part 19 is the same as Part 18 of the CPR. It's founded on the same principles, and therefore decisions of the English courts are relevant. Now, what I'd first like to draw attention to is the case of Georgia and what was said there. In Georgia, the issue there was interrogatories as opposed to further and better particulars. And there is a difference between interrogatories and further and better particulars. In all cases, the requests have to be proportionate and consistent with the overriding objective and so on. But there is a fundamental difference between looking at a pleading and saying, what is your case exactly, as opposed to an interrogatory, which is going a step further. And in Georgia, Justice Giles, he actually set the test out for interrogatories and relying on the what I call National Grid 1, so the first in the National Grid cases. If we actually go at paragraph 22 and the quotation I've given there says, necessity is a stringent test. This in relation to interrogatories cannot be necessary to obtain information or admissions which are or are likely to be contained in pleadings. Now, many of our requests well, they're directly referable to the pleadings because they come under the paragraphs. They're reference to the pleadings, but they're actually asking fundamental points about what the case is in those pleadings. And then also in National Grid, there are 3 further relevant points, and I've set those out at paragraph 24. The first is that Mr. Justice Roth found that in a scenario of asymmetry of information between the parties, the information requested does serve a clear litigious purpose and promote the fair conduct of the action. And we say this applies here. We simply don't have information, or we wouldn't be expected to have information that the defendant would have, given her position as an owner of shares, as a director, general manager of the entertainer previously. The next point is that a good reason for making a Part 18 request may be where the further information requested may be very, very significant for a summary judgment application. So by way of example here, we're saying that there is no link in the amended defence and counterclaim between alleged misconduct, which itself is very vague, and causation of loss. You can't track it through the pleading. The third point is that, and one issue that might go against us is that, or a factor weighing against a Part 18 request being granted is if it's difficult for the party to actually obtain that evidence. But we say that, well, we have no reason to believe that there would be any difficulty in actually providing the evidence that we've asked for. And certainly no, it's not been said we don't have this or anything like that, or we can't access it.
Ms. Stewart, I'm sorry to interrupt you at this stage, but I think my burning question is, and I think we raised this at the directions hearing last time, obviously we haven't yet arrived to the point of witness statements, and in contemporary litigation, at least in my experience, I'm seeing a lot of information being fleshed out in the witness statements, and then I know what you're about to say. I know exactly what you're about to say, which is the point that you made earlier, which is that why should we keep going around and roundabouts? But if the defendant provides a witness statement and you're then given an opportunity to respond to that witness statement within a particular period of time, shouldn't it be at that stage, in that period, that a Part 19 request is raised?
Well, I fundamentally disagree because, and I'll take you through, if I may, through the, and maybe this is, I mean, certainly in the High Court in London, I appreciate we're not in the High Court in London, but we're in the DIFC, which follows
similar
a
practice.
very similar approach, yes. So let's go first. Let's go first in that case, because I do attack this square on from paragraph 30. First of all, paragraph 30A, and this is first of all an extract from the White Book, and I've underlined the relevant parts. And it starts off by saying, whilst in the early period of the CPR, it was thought that the need for extensive pleading, including Part 18 particulars, could be reduced by the requirement of the exchange of witness statements. This is the White Book from this year that's just been printed. However, the importance of the essential parts of a party's case being pleaded in the statement of case has continued to be emphasised and restated in numerous cases since. And then we get on to Three Rivers, and I've underlined some parts of the part of Three Rivers, while my learned friend has underlined other parts of it. Of course, a balance needs to be struck between the need for fair notice and excessive demands. Totally understand that. But if we go to, and it's towards the bottom of that page 9, the basic purpose of pleadings is to enable the opposing party to know what case is being made in sufficient detail to enable that party properly to prepare to answer it. Now, we were coming up, we in an ideal world, we would have already exchanged witness statements. Why should we be denied the opportunity in a witness statement to be able to answer the case that's being put to us? We don't have sequential witness statements. We have statements of case.
But Ms. Stewart,
Now,
I think going to that same principle, I think, and the authority that I've seen is that if you were to scope out the nature of the claim being made, which in my opinion, I can see that the defendant has done that. They've scoped out the parameters of the claim that's being made against your client within the counterclaim, and they then will delve into the detail of what that is exactly through a written narrative being the story that's told by the witness.
well, it may be necessary to go through to the actual request then. I'm going to the law and I've set it all out here, which says very clearly, it emphasised the importance of pleadings. It also emphasises that the more serious the allegation of misconduct, the more important it is that proper particulars are provided. For example, at page 11 of my skeleton, the Allpay case says that the appellant has the right to be put in the position where it can properly prepare its case, needs to know the case, not only before it gets to the hearing, but before it prepares its witness statements. Going to D, the starting point must always be the pleadings. And then we get to a more recent case, which is the case of Pacific. And if we see that that's in the next on the next page at 12, the function of a request is to identify the material facts. The material facts have not been identified. Scoping out in very vague terms is just not good enough. And here it says, so, and then at 20 of Pacific Biosciences, a major objective of case management is to ensure that statements of case do set out the party's case, define the dispute between them, not just scope it out in vague terms. As part of the responsibility for managing cases, the court must ensure that parties plainly state the factual ingredients of their case so that the true nature and scope of the dispute can be identified. And then crucially, in the next paragraph, defining issues has, I think, two aspects. First of all, defining what will be debated, and secondly, eliminating what will not be debated. The second aspect is every bit as important as the first. Now, with all of that in mind, the DIFC court has found that, of course, all the elements of a relevant cause of action and the facts necessary to reach a particular legal conclusion need to be pleaded. So again, it's not a matter of scoping out in vague terms what the claim might be. It's actually saying this is the claim. We get to some more basic points about legislative provisions, which I'm sure you've seen and you're familiar with. It may be a good idea now, therefore, to go to the actual request so I can put some meat on the bones, as it were.
I think, and just to you know, be able to reflect where my thought process is at the moment, I'm not denying that a Part 19 request can be made at any stage in the proceedings. It can be made very early on. It can be made after the exchange of pleadings. I think my concern is that it waited this long. And my second concern is, or not concern, but I think it's the question is really a subjective one, where at the moment I feel as though the relevant particulars of the defendant's claim have been sufficiently scoped out. And I think your duty at the moment, Ms. Stewart, is to say, is to prove that no, they haven't. And this is the level of detail that the particulars ought to include. So yes, I think it would be helpful to go through each and every request. And I think at the last hearing, when we had the directions hearing, the reason I said that let's hold off exchanging witness statements is because you took me to a very example of how the particulars at some stage did not have enough reference as to what the claim was about. And I was convinced at that stage that, you know what, you have a point. So yes, let's go through each and every request, and you can cross-reference back to the defence and counterclaim.
Yeah, I'm afraid the devil really is in the detail with this one. So if I could just turn to timing, it is unfortunate this wasn't done earlier. I hope you've taken on board what's been written in the witness statements, that Nimble Legal were instructed at the tail end of last year. They faced disclosure issues, and they faced what they inherited, as it were. It was less than optimal. The disclosure phase finished in the beginning of March. Attention was turned to witness statements proper, having had to address the various need for affidavits that had been directed prior to that. And very quickly, it was identified, actually, we've got a real problem here. We don't know what we're supposed to be covering in the witness statement. So,
I get that, and that makes sense. But at the same time, what I don't want to see is parties saying that, hang on a second, I'm very sorry, we instructed the wrong law firm initially. So the other law firm now needs to pick up the slack, and please excuse us while we get to that, because that's obviously done at the other party's expense and cost, which is not right. So I'll mention it now. I've mentioned it in other hearings. Just because a party has elected the wrong representation initially and then moved on to a law firm that perhaps does know what it's doing, for lack of a better phrase, this doesn't mean that they are afforded any excuses to then file applications which are delayed. So
no, I totally understand, and that's why I said at the beginning, it's regrettable. And believe me, the claimants wish this had not happened. But what is relevant is the overriding objective, and I would say getting the case back on track. Let's finesse the issue, see what's what, and then it should run smoothly. It's very simple, rather than having what one often sees are poor pleadings. The points aren't taken, perhaps because the lawyers aren't up to it generally, and that is very often the case. And then trundle to trial, voluminous witness statements, accusations, counter-accusations, thousands of pages of documents, and yet actually the issues haven't been focused on. And all that does is escalate costs. One sees it time and time again. Anyway, but there we are. Right, so let's get into the detail again. This is the paragraph that I took you to last time, and it's at W28. And the reason I'm taking it to you again is because it's so very important to the whole nature of the case. It really seems to go to the core of what the defendant is saying against us. So first of all, paragraph 33, are you there, may I ask?
you said W28, I'm at tab 28, but do you mean page 28.
Oh, in W28, yeah.
Okay,
so-
so bear with me, please, which is on the amended defence and counterclaim. I'm there, thank you. Yes, please proceed, Ms. Stewart.
So the claimants are accused of breaching various duties, various terms by, among others, 33.1, and this goes to all of the, this goes to requests 1 to 3. And then it goes more broadly into some of the further requests in relation to 33.1.1, which is the paragraph below. So, sharing the entertainer's confidential information. Well, I've never seen a breach of confidentiality claim where the actual confidential information has not been particularized. What is the confidential information? This morphs later on to highly confidential information. So the point is that apparently we disclosed some confidential information and highly confidential information, which, and we see this in the first sentence of 33.1.1, caused a loss of value in the business sale. So how did that happen? Now and then we have various allegations about convening meetings, that we would receive free equity. What does that mean? And as a result of all of this, apparently, and we have this phrase, a secret plot. Now, from the beginning, well, certainly from the beginning of Nimble's instruction, we've been absolutely clear that, and we've provided piles of evidence which shows that the defendant was fully aware that the three individuals, so the claimants and Mr. Ashford, were looking into an MBO. And there's a large amount of evidence provided in support of that at W103.
Yes, I'm there, thank you.
So what we have is, if we go to D, we have, and this is the documentary evidence, that the defendant was fully aware that an MBO was being pursued. We have a slide for a board pack meeting. This is for Date's board meeting on the 25th of 2017, 25th of April 2017. And you can see that at W339.
Yes, thank you.
The next document, which I can give you the reference, I don't know whether you want to go to it or not, but W340, and then that's a letter, June 2017, which was forwarded to the defendant, and that considers both an MBO and an IPO. Then there's a letter at W343 that's dated August 2017. That's from another private equity house, and that was forwarded to the defendant on the same date, and that's titled Indicative Offer to Support an MBO. Then we have W352. That's September 2017, a revised offer to support an MBO, and that's to the defendant. We have a term sheet of September 2017 provided by Linklaters, and we can see that that's been provided to the defendant as well. And if we look at W372, there's an entire page devoted to management. Then if we go to W374, that's a draft letter of October from the private equity house GFH, who eventually, who were the ultimate investor. And that was forwarded to the defendant on the same date. And that also makes clear reference to a non-binding indicative proposal to acquire, alongside senior management, 80% of the shares. And then there's another one, which was the non-draft letter, so draft taken off, which again, and that's at W380, which is makes clear reference again to a non-binding indicative proposal to acquire alongside senior management and so on. So, secret plot, we don't understand. How exactly was this secret? Now, we've been thinking, what are we missing here? And so we thought, well, maybe the defendant doesn't actually understand what an MBO is. So we asked the question, what's your understanding of an MBO? Then, if I just go back. And then we move on to the rest of, I've covered the first sentence of 33.1.1. If we then move to the rest of the of that sub paragraph, and that covers requests 4 to 12. Now, it then moves from the cause is everything that happened in the above paragraph to then talking about a competitive tender process that was somehow negatively impacted. We're not aware of a competitive tender process. We don't know what, and something that's key to a drop in value of shares, or, you know, a price that is not as perhaps as high as she might have liked, is how competitive was the process? Who were the bids from? We know what we know, but we don't know what we don't know. You know, there's the fundamental asymmetry of information here. The defendant, she was the one who had the shares. She was selling them. We weren't. We worked for the company. Yes, we wanted to be part of an MBO, but what's this competitive tender process? And how? They say that the transaction value and the competitive tender process was negatively impacted, given that GFH were able to structure their offer. Well, how were they able to structure their offer? On the basis of confidential information disclosed. Well, what confidential information was it that was disclosed that enabled them to structure their offering, whichever way it's alleged that they structured their offer that was somehow negatively impacting X, Y, and Z? We do not understand.
Let me ask you a question, Ms. Stewart. Given that a lot of this information is perhaps supported by evidence, wouldn't it make sense that it would be discussed again in narrative with reference to an exhibit, which then sets out exactly what, or rather backs up that person's story or narrative? So, for example, if Miss Benton is saying that there's a secret plot, for example, she might say that there's a secret plot. She might give some detail of it, but really the devil in the detail would then be in the witness statement, where she would tell her story of what that secret plot is, and then she would exhibit other emails, for example, that would go to back up her connotation. Now, I do agree with a point that you're probably about to make, which is that these types of documents should have been admitted through the disclosure process. And you're probably going to say that there's been nothing of that sort. There's been nothing in the document disclosure process that says so. But again, I don't know the level of review of the documents that were given to you, because I know that you have also said your client says that there's been a document dump. So I don't know whether that means that there's not been a proper review of the documents that have been handed to you, or...
Oh no, there's been a very proper review now. When there was the document dump, Nimble Legal, and that was part of the timing issue, they ordered everything, they put it in an index, chronological order. I have been through these documents myself now, rigorously. And I'm mystified. That's all. I can't say more than that. And in any event, one has to say, surely one has to put in the pleading, what is the link between the confidential information, whatever that is, and how it caused a drop in the price, and how that's linked to structure. We've got a heavily redacted SPA. Are we supposed to be guessing this? This could be set out. You know, this pleading goes on for pages and pages. There are just some salient points here which could be set out very concisely, which aren't. And they're the most important points which aren't set out.
I agree that some example probably should have been given.
Yeah.
I do agree with that. So some example of what confidential information was perhaps disclosed, why Ms. Benton thought that perhaps there was a secret plot despite there being clear evidence of an MBO.
Well, it's not an example that should be given. There should be a clear link of causation by reason of X, Y, Z led to loss. And there has to be a logical connection between those points, not just freestanding allegations. It's not fair on the claimants.
Okay. Now using other examples, and I think there was some documents that you were referring to within the requests that you say weren't provided through document disclosure. So would you like to walk me through those?
Well, I think one of the points that we seem to be at odds with is whether you can seek documents through the through Part 19, and we would say that you can. You don't need to go, you know, if it's related to the pleadings, it's abundantly clear from the terms of Part 19 that you can seek documents. I don't know whether you'd like me to take you to the relevant parts of that.
No, I've seen 1910 subsection 4, which is where a request relates to a document, identify that document, and if relevant, the paragraph or words to which it relates. So I think that given that disclosure has taken place and clearly your client's not satisfied that the full extent of disclosure has been exchanged by the defendant, I'm convinced that yes, that the Part 19 technically can include a request for further documents. I don't see why not. And I think that in the event those documents are not referenced earlier in the particulars or referenced in, I mean, the witness statements, again, we can't really talk about that because no witness statements were exchanged, but the fact that they weren't even flagged in the document production process is a cause for concern. So the question then remains is, if they're not produced now, when will they be produced, given that trial is listed for September? So no, I'm convinced on the document front. You don't need to take me through too much detail, but I'm curious to know what kind of documents are being requested.
It's quite simply, if we look at the pleadings, we are alleged to have been in breach of various duties as officers of the company, which is another point that I think is important that I'll go into. But so in the Mems and Arts, and more particularly the Articles of Association generally, it would set out the powers, the responsibilities of the director. Now, overlaid with that, you'll have the law as well, but it's absolutely fundamental to have the Articles of Association if you're facing allegations of breach of director's duties or breach of officer's duties. So that's why we were seeking the Mems and Arts for both date and for the entertainer. Shouldn't be that difficult. And I would have thought it'd be one of the first things they would have looked at when they were pleading this. And that does, I don't know if that addresses your...
It does, but wouldn't your clients in their capacities as CEO and CFO respectively, or COO, wouldn't they have access to the Articles of Association?
They were... Well, first, I think what's important to realise is that they had a title of CEO and COO of the entertainer. They were not appointed as managers. They were not directors. Therefore, they were not officers of the company, of the entertainer. Now, there was a short period of time when the second claimant was a director of Date. He doesn't have, this is a Cayman company. Why would he have those, why would he have those documents? He's left the company. Now that, I don't know if that addresses your point satisfactorily.
It does, Ms. Stewart.
The next, and there is another point, which is that we are concerned about, which are the numerous references to the CCL, the Commercial Companies Law. We've drilled through the law. What you will see throughout the pleadings are the various alleged breaches of the Commercial Companies Law. Now, in our analysis, and it also says in the RDC that you need to explain your reliance on particular provisions. Now, our analysis of the law indicates that the CCL didn't apply. This was a DCCA company to which the CCL simply doesn't apply. I can take you to the relevant the DCC regulations in force at the time were actually exhibited to show the point. And if I could take you to, you would just bear with me one moment. It's the DCC regs at right, W236. $110.4, the provisions of the CCL are disapplied in their entirety, except as expressly referenced in Regulation 101. If you then go to Regulation 101, which is W233, that relates to winding up. So, and we also see the CCL in force at the time, and which isn't actually exhibited here, but the CCL in force at the time also states Article 5 that it doesn't apply in free zones unless the free zones allow that. Well, that's the essence of it. So there are all these references to the CCL, but how is it relevant? Maybe we've missed something. Just explain it to us as the RDC requires you to. That's all we're saying. What Miss Burt says in her witness statement in relation to the officer point, because we say that in relation to the entertainer, it's news to us that we were an officer of the company. Now, in response to that, she relies on Article 162 of the CCL. And she says that because we were executive management, we were an officer, or that's the sense in which she's using the term officer. But the actual provision that she relies on only came into force in January, on the 1st of January 2021, when the old CCL was repealed. So, but the actual relevant events, the latest relevant event was when the second claimant left the company. That was in December 2020. And the actual settlement agreements were entered in June 2018. So, and the payments had been made, well before the CCL came into force, the new CCL. So how is 162 relevant? These are some kind of pretty basic points that we should not be hurtling to trial with unless we've got, the backbone sorted out. If we go to the next, should I go on to a further issue?
Yes.
Another example.
Yes, I think that would be helpful.
Yeah.
Just before you do, I note that we've got a 2-hour hearing. We're about an hour through. I'd just be grateful for an indication of timing because there's a lot already that I'd quite like to respond to.
And I think there's been some criticism of my learned friend of the number of requests. The point is,
sorry,
that
Ms. Stewart, just so we can manage everyone's expectations in terms of timing.
I'm nearly done. It depends.
You're nearly done. Fantastic. Okay.
I didn't realise that you hadn't seen the actual pleadings. So yeah, or rather the request. So I've had to go into it in more detail than I'd anticipated.
Thank you for walking me through it. I think we had a similar issue last time. Ms. Hurst, are you available over the 2 hours in case this hearing lasts for a bit longer than the 2 hours?
I am, yes, well, I can make myself available if necessary.
Thank you, Ms. Hurst.
Request 17, by way of another example, we say that the things we're asking for there, they're just basic elements of a cause of action in misrepresentation. And we're simply asking for the provisions of the Misrepresentation Act that are actually relied upon, which we're entitled to do under the RDC, or to put it another way, that the defendant is obliged to provide us. Looking through paragraphs 34 to 37 of the amended defence and counterclaim, and that is at W32. Are you there yet? Right. And the misrepresentation part appears, although it's not clear to be covered, as I think between 34 and 37, but maybe not. At 34, there's an allegation that in omitting to mention that the claimants had been acting against the interests of the entertainer in a breach of their fiduciary duties, the claimants had represented that they were aligned with the co-shareholders of Date Holdings. Now, so there's some kind of alleged representation based on omission. Now, it's trite law that you can't, ordinarily, rely on silence or omission for misrepresentation. There has to be something else. Here, the something else solely appears to be forming a key part of the deal team. But the claimants were employees of the entertainer. The second claimant was an employee of Date. A director of Date. That of itself, they owe duty to the company. But why would an employee, for example, of the entertainer owe duties to a shareholder of a company, and not even the shareholder of that very same company, a different company? It's very difficult to see. Then if we go to the next paragraph, 35, we have, from the above, the final ESOP agreement, and by that they mean the settlement agreement, was entered into in reliance of, and then we've got 3 different points. So reliance, okay, well, reliance, that doesn't have anything to do with, well, it doesn't usually have anything to do with a breach of contract, for example. Think, okay, and then we get down to 37. Separately, as set out above, given the defendant was induced into entering into the settlement agreements, we'll call them, in reliance of the claimant's misrepresentations, as outlined above. Well, the reliance at 35, there are 3 reliances here. So is it also being said that 35.2 and 35.3 are some kind of, somehow related to some kind of representation, alleged misrepresentation of some sort. And why isn't it just pleaded simply? It's a muddle. It's a complete muddle. It's a complete mess. And then it also says in 37, in reliance of the claimant's misrepresentations. So plural, it could be a plural because it's claimants. It could be plural because there's more than one misrepresentation. Don't know. So all we've done in this section in request 17 is to say, right, just tell us just give us the basic ingredients so we can work through this. And we know what the case is against us. Very quickly, I can go to request 21 to 23. That pertains to our case. We're just trying to work out what we're owed, including interest. So what's relevant, for example, is to know, first of all, what came in to the buyers, the net amount, and when it came in, and therefore when we should have been paid under the terms of our settlement agreement. The defendant says, or Ms. Burt says, oh, we've given you all the information. Well, no, they haven't. We can't work it out from the information that's been provided. I could go into detail on that, but all I can say is they haven't. I won't.
I think you've walked us through a fair few examples, Ms. Stewart. Thank you. Is there any other submissions you wish to make before we hear from Ms. Hurst?
No, I think the only thing I would say is that there are the requests at 5 to 9, they fundamentally arise from asymmetry of information. For example, it was a merchant bank called Rain who ran the due diligence process with the private equity house who eventually were the investor. Now, in a due diligence process, it would usually be cards on the table. If someone's investing tens of millions, they want to know what they're buying. So the questions go to, well, you're saying that confidential information, that somehow we caused a drop in share price in some way, shape or form. But wouldn't you have had to put your cards on the table anyway in a due diligence process? So there are a number of questions trying to work out. We don't know exactly what went on with this due diligence process. We're trying to work out, again, it goes to causation. Was something, is the defendant saying, oh, actually, we would have concealed X, Y, and Z from the investor? And therefore, would they have been entitled to? So that really sums up that batch of requests from 5 to 9, and basically based on asymmetry of information, different aspects of asymmetry of information, but I gave you one example. Oh, and then the final thing, no, there is one more point, awareness. When precisely the defendant, so this is, for example, request 12 and 13, were accused of entering a secret plot, but the claimants remained employed at the entertainer for a couple of years after the SPA was entered. They left as good leavers. So, oh, have we lost? So when did the defendant become aware of the alleged misconduct? Let's say, for example, that she discovered about the so-called secret plot well before the initial payment was made under the SPA, or to us. There are all kinds of issues that raises, affirmation, estoppel, all kinds of issues. So just tell us the dates. When you say you became aware of whatever it was that we've allegedly done. These aren't difficult questions, or they shouldn't be. unless you have anything further, I think I've...
No, that was very helpful, Ms. Stewart. Thank you. Ms. Hurst, I think you've got a couple of things to rebut, if you will. So over to you, please. Thank you.
Thank you, Madam Registrar. I mean, I think I'm grateful that you've obviously read our skeleton, and I can say you're correct in your understanding that we do object to the totality of these requests. It's not simply, although it is in large part, a matter of the disproportionality of the totality of those requests. But in respect of each and every request, we say that they don't satisfy REC 19.6. And you've obviously been taken to that, but I would just repeat at the very outset of my submissions that is the test that Ms. Stewart has to overcome. She has to satisfy you that the requests are concise and strictly confined to matters that are reasonably necessary and proportionate to enable the claimants either to prepare their case or to understand the case they have to meet. It's not simply a case of them realising very belatedly in this litigation that there are some bits of the pleading that they might quite like to have explained to them so they can tailor their witness evidence. That's not the test, and the test is rather stricter than my learned friend would have you believe, and we say they plainly don't satisfy it. You'll have seen from the skeleton that there I think we say 5 points. They are interconnected, but what I'll try to do is to take the points of principle and then go down through into the detail. So point number 1, we say that as is plain from the face of the request, they're not concise and they're not strictly confined. We've got 7 pages of detailed requests. They're at times overlapping. They're numbered 1 to 25, but there are in fact, by my count, 51 sub-requests, which go well beyond what's necessary and proportionate. We find them difficult to understand because they make composite requests under a number of different headings. Different paragraphs of the particulars of the pleading are lumped together without any explanation as to actually what the difficulty is in understanding them. And it's a remarkable feature of my learned friend's submissions that actually we didn't spend very much time looking at the requests at all. What she did was take you to the pleading and make some general complaints about the pleading, but we haven't gone number by number through the requests and line by line, and she hasn't shown you what the request is. Instead, she's shown you the bit of the pleading that she doesn't like and said, and therefore our request is reasonable. Well, what request? I have to say I agree with you, Madam Registrar, that the bundle is fairly hopeless in this regard, in that we don't have the requests under a separate tab, so they're easily referable. I've actually got mine separately extracted on my screen, but I'm going to have to, I'm afraid, go through the requests line by line, because in many respects, the explanation that's been given by my learned friend, which we're hearing for the first time today, doesn't actually bear any resemblance to the request that's being made. But that's a point of detail. So that's on point number 1, we say, plainly, they're not concise and they're not strictly confined. It's a rambling set of requests. Point number 2, on the law, we say that the test of necessity is a strict one. That's clear from the authorities, and it will not be satisfied where there are other procedural steps available to enable a party to prepare their case. And most obviously, those are disclosure and witness statements. Now, Madam Registrar, you said you were convinced on the point about disclosure. I am going to rebut that. We say it's not acceptable to use an RFI to get documents that a party failed to request during the request to produce phase of the litigation. And we say with equal force that it's unlikely, and in this case it isn't, appropriate to use an RFI when factual evidence is about to be exchanged, which covers the points. And it was telling that in my learned friend's submissions, she repeatedly referred to seeking evidence quote from us. Well, that is exactly what she would have had they waited until the day after they filed the application, when witness statements were due to be exchanged. So we say that a response to an RFI shouldn't be ordered by this court, where what the claimants are doing is seeking documents which are retrospective requests for disclosure of documents that they didn't request during the request to produce phase of the litigation, and or documents that have already been disclosed to the claimants during the disclosure process. Now, I strongly object to the suggestion made by my learned friend that disclosure has been inadequate by the defendant. She, of course, wasn't involved at that part of the litigation, but in fact, we have recently spent 5 months dealing with contested application over disclosure, which related to the claimant's wholesale failure to comply with their disclosure obligations. There was a hearing before you, Madam Registrar. There were 2 hearings before Justice Giles. They resulted in the claimants being ordered to produce substantial affidavit evidence. And as I will show you, it is plain on the face of that affidavit evidence that the claimants understand full well what the case is that they're being asked to meet. And so we do say that there is a sort of forensic amnesia in the claimant's submission today, that they don't understand the case in a number of key respects, because the parts of the case they profess not to understand are aspects which have already been fully engaged with during that contested disclosure phase. And moreover, that key documents going to the parts of that case have been identified. There were 2 full affidavits from each claimant and their solicitors. And I will show you some examples of that, but we don't accept that the claimants don't understand the case that they have to meet. And that is another reason why the strict test of necessity isn't satisfied. And finally, and perhaps I'll deal with this point first, we say that the timing of this application is particularly egregious, and a further reason why, in your discretion, it ought to be refused, as the balance of prejudice clearly weighs against ordering such a wide-ranging RFI to be responded to at this stage. So on timing, I think there are 2 points to make clear at the outset. Firstly, a case management order was entered into on the 9th of March. That was an order that was entered into by consent. It followed, as I say, this protracted document production dispute and the hearings in relation to the claimant's failure to comply with disclosure. And the parties agreed to procedural deadlines by consent in that order. Now, I do emphasise the fact that at that stage there was not a whiff of a suggestion from the claimants that a substantial application was going to be made, which would derail the timetable that they were happily agreeing to at that phase. So on the 9th of March, they agreed to exchange of factual evidence on the 6th of April, and there was no suggestion whatsoever that there would be a difficulty in complying with that deadline. Then, less than 2 weeks before that deadline, the RFI is served. Now, we find it difficult to believe that that was an idea that suddenly occurred to them in between agreeing to the case management order and filing that up, serving that request on the claimants. Quite properly, the defendant wrote back and said, look, we're due to exchange witness statements. We're not in a position to engage with this. We're heavily involved in the preparation of witness statements. They had requested a response within 5 working days, which we say is contrary to RDC 19.3, which requires them to give a reasonable time to respond. We say that was plainly unreasonable. We said, we'll try and engage with you after exchange of witness statements. That wasn't good enough. We then proposed in correspondence a couple of options of dealing with this. One, why don't we exchange witness statements, see if any of your complaints still stand, and then we can deal with your RFI. Or 2, why don't we push out the deadline for witness statements, and we'll do our best to deal with those requests that we think are reasonable and proportionate. Neither of those suggestions was acceded to, and the day before witness statements were due to be filed, this application came instead. And we do say that that is a regrettable failure to comply with the overriding objective when, as I'll go on to show you, it's pretty clear that the law says that the test of necessity on an RFI isn't going to be satisfied if factual evidence is going to cover the point. It's perfectly appropriate to have a pleading which sketches out the main allegations being made and that full particulars are provided in witness evidence. And I'll come on to that law in a second, Madam Registrar, but the other point about timing that I want to make clear is quite how late in the day this is. Working backwards, we have a trial listed for 2 days in September. We have a PTR listed on the 31st of July. We are already 7 weeks from the date when witness statements were due to be exchanged. And expert evidence ought to be being exchanged around about this time. We're at a point, and currently that procedural timetable is suspended. We are at a point in time where the parties ought to be heavily preparing for this trial, and it's a trial that's been in the diary for some months. And yet we are being sidetracked by an RFI, which isn't necessary, and could, we say, all of the points that are being raised would either be dealt with in witness evidence or they're matters for submissions. Particularly puzzled by some of the arguments on UAE law, but we'll come on to that in due course. But in working back from that timing, it bears emphasis, and I've set this out in my skeleton argument, it bears emphasis that the pleading that is being impugned, the claimants have had that pleading for over a year. It was filed on the 1st of April 2021. That was the unamended defence and counterclaim, but I should make clear that the amendments do not make any new allegations or new defences. The amendments arose as a result of consolidation, because there was originally 2 claims made separately by the 2 claimants. They were consolidated, and the amended pleading was purely to put the 2 defences and counterclaims together. So they've had this defence since the 1st of April 2021. At that time, no complaint was made that the claimants were unable to understand the allegations. No RFI was made. Instead, on the 25th of April, each claimant filed a reply. And I'll show you in relevant parts what that reply says about the pleading. But the paragraphs that my learned friend now seeks to impugn are either admitted or the defendant is simply put to proof on them. And now, of course, as I'm sure we all know, where someone's put to proof, the idea is that we lead evidence on that in due course, and that is exactly what the defendant intends to do. Then on the 16th of May, the defendant filed her reply to the defence to counterclaim. No criticism seems to be made of that document. There was then an application by the claimants for immediate judgment, which was then withdrawn. Again, during that process, there was no concern about the clarity of the defendant's case. The first CMC in this matter was held on the 7th of July. Now, I'm sure we're all familiar that normally if there's an RFI of the pleadings, it's desirable that the pleadings are closed at that stage, that the parameters of the pleaded case are explored and teased out, and that they are closed prior to disclosure. It's obviously desirable that the pleadings are settled before we move on to document production. But there was no suggestion at the first CMC that there was a problem with the pleadings, nor was any intimation given that the claimants were unable to understand the case that they had to meet. Then we have some procedural steps just dealing with consolidation. So the document you've been looking at, the amended defence and counterclaim, that was filed on the 19th of July. But as I say, that was in materially the same terms as the April document. And then we enter disclosure. And I do emphasise this because we had standard disclosure on the 4th of August. We then had the exchange of requests to produce. And in my submission, that was the appropriate time for the claimants to make the request that they now make for example, the corporate documents of Date Holdings or the entertainer. I disagree on the law that a Part 19 request can be used simply to request a document to be produced. Perhaps it's convenient to this is a sort of sidestep in the chronology, but it might be convenient to just deal with that very briefly here. Of course, the regime for requesting documents be produced is Part 28 of the RDC. 2816 says, within the time ordered by the court, a party can submit requests to produce. That's the time at which parties list out the things that they don't think have been covered in standard disclosure, and they make their requests for further documents. And as I'll show you in respect of some of the requests being made, the claimants did make requests and they were answered. And so the disclosure has already been given. And in respect of other requests that are now being made, no request was made at that time. And we say it's now far too late. The request is not being made within the time ordered by the court. And just to cover off that point, my learned friend places reliance on RDC 1910. What that rule says, Madam Registrar, is a request, whether made by letter or in separate document, must. And then subparagraph 4 says, where a request relates to a document, identify that document and, if relevant, the paragraph or words to which it relates. Now, in my submission, it's clear that what's contemplated there is that one can make a request in relation to a document that's been produced, but that doesn't, and if the request relates to a specific document, you need to identify what paragraph or what words you're asking to clarify. But what that doesn't say is a request can be a request to produce a new document that hasn't been produced I'm sorry, I'm getting a message that my instruction solicitor has been kicked out. Let me just see if it's possible to readmit. I think Antonia Burt's just rejoined.
I think she's back.
Perfect. Sorry about that. I was getting all sorts of alerts on my screen. So we don't accept that it's appropriate to use RDC 19 to ask for documents that weren't requested during the disclosure phase. That's not what 1910 subparagraph 4 envisages at all.
But Ms. Hurst, I'm sorry to interrupt you. I've got a habit of doing that with council. My query is, when you think of the overriding objective, if you've got a document that wasn't requested in standard production but requested later on, wouldn't it make sense that a party would rely on this very section 1910(4) to say, sorry, we didn't request it before, but now we do find that this document is relevant, and in furtherance of the overriding objective, it's better that we request it now. Actually, to go a step further, we're assisting you by requesting it now, because essentially what you're proving is you're producing rather a document that backs up a statement that you've made or a claim that you've made. So I would disagree to an extent to say that you cannot request certain documents after standard production. I think the word standard production perhaps implies that there is a standard time for which people may seek production of documents, and that's typically before witness statements are exchanged. But there's nothing that would necessarily prevent a party from making an application to the court under this section or under Part 23, for example, to say that there's a document that has not been produced to us that we wish to see. So what do you say to that?
Well, with respect, Madam Registrar, I wouldn't put in quite those terms. Any application to produce documents is not governed by RDC 19, it's governed by RDC 28 as the relevant part. It's clear that there's a timeline for requests to produce, which fall outside of standard disclosure. And then there's obviously then party can make objection to the request for grounds to the request to produce. And there's a regime for saying on what grounds a party can object to a request to produce. And there's then obviously the next step is that the court orders on request to produce. There's clearly, the grounds are clearly set out for the grounds for excluding documents from production, public interest objection and so forth, and then a document production order is made. And so if one is to make an application retrospectively for additional documents to be produced, I would say that it is governed by that part, not by part RDC 19, not least because RDC 10 subparagraph 4 says a request relating to a document, not categories of document or broadly identifiable categories of document that may or may not be in the claimant or the defendant's possession. It says identify the document and the paragraph or words to which the request relates. And that has to be a request to clarify, not a request to produce. So I don't necessarily accept that a late application to produce documents is governed by RDC 19. I'd say it's governed by RDC 28. But in any event, I don't need to press you or waste the court's time on that issue of principle, because we'd say even if you have a discretion to order belated disclosure of documents, it's this is about as far a case from being a case where you ought to exercise that disclosure as it's possible to contemplate. And the reason I say that is that the parties have just been through 5 months of contested disclosure. If I jump back into the chronology, standard disclosure was given on the 4th of August. On the 18th of August last year, the parties exchanged their requests to produce. The claimants requested a number of documents. And I emphasise that, and this is covered in Ms. Burt's witness statement at paragraph 19, one of the requests to produce that was requested by the claimants were documents relating to the consideration received by the defendant as part of the business sale. And those documents were produced. That's reflected in Justice Giles's order of the 31st of August at paragraph 4. So the claimants asked for the documents relating to the consideration on the sale, and they were produced. So the suggestion now that they're asking for more information because the disclosure hasn't been given is regrettable insofar as it suggests that my clients have not complied with disclosure, and it's wrong. It's simply wrong on the procedural chronology. The document production order was made by Justice Giles on the 31st of August, and then, as you can see from the master bundle, but from the brief summary in my skeleton argument, paragraph 13 onwards, there was then a long and contentious period where the defendant had to write several times to the claimants, pointing out they had entirely failed to comply with their disclosure obligations, that they hadn't produced documents, that they hadn't produced compliant document production statements. And then an application was issued in November. In the course of that application, there was a directions hearing before you at which you directed the claimants each to produce an affidavit explaining certain aspects of the disclosure that they said that they didn't have or couldn't provide. And then further affidavits were ordered by Justice Giles to be prepared and produced in January. And I emphasise those affidavits because it's quite clear when one looks at them that both of the claimants dealt in detail with the factual allegations that are made by the defendant, and they provide their own story, their own version of events. And it's clear that they understand, well, first, two things. One, they understand that the case that's being put to them because they've engaged with it already substantively in witness evidence. And two, they specifically identify documents that they say go to those allegations, or that they say are or are not relevant for reasons that they give. And so again, the suggestion that this hasn't been adequately thrashed out in disclosure is, in my respectful submission, completely wrong. Now, as you've seen from the chronology, there was a hearing in December, there was a further hearing in January, and this process culminated ultimately in February with a substantial costs order being made against the claimants in respect of that application, because they were found to be the unsuccessful party. The defendant had established that they had failed to comply with their disclosure obligations. And so I say, if you have any residual discretion to order retrospective production of documents by the defendant, which are asked for out of time, which in my submission aren't properly asked for because they're not asked for under the relevant part of the RDC, those requests are being made after we have exhaustively canvassed disclosure in these proceedings over 5 months, using up a lot of court time and a lot of party resource in the process. So the idea that the claimants can now come to court and ask for more documents, in my submission, that the balance of, in your discretion, that request ought to be refused. We've had enough court time and resource vented on that issue, and the claimants were found to be a non-compliant party in that respect.
Ms. Hurst, I think the difficulty that I'm having at the moment is I feel that the claimant is requesting a lot of these documents on the basis that they go to help support your client's counterclaim. They go to help support the relevant submissions raised by your clients about, secret ploys or confidential information being disclosed or misrepresentations for that matter, whatever the case might be. So the fact that they hadn't requested these documents during the standard disclosure period, certainly that leads to cost, it leads to delay, it's procedurally incorrect that it was not, these documents were not requested in time. But ultimately, if your client was to prove its case, and if your client was to succeed on the points that it makes in its counterclaim, it must produce these documents, because as we all know, making these allegations or raising these claims within a counterclaim and not backing it up with the requisite evidence will necessarily mean that your client's claim fails because it has not proven its case to the standard of proof required. So the question is, are these documents going to be exhibited to the witness statements? Because if they are going to be exhibited to the witness statements, then fantastic. It means that your client has backed up its case, and it means that the claimant's questions have been answered. But if your client does not wish to produce these documents at all on the basis that it doesn't have the documents or it doesn't think that they're relevant, that's another argument that you can raise. So I guess
Well,
what I'm trying to say is whether or not this application is being made under Part 19 or Part 28, or Part 23 for that matter, my view is that RDC 19 and RDC 28 can be read together. They're not mutually exclusive. So if certain documents are being requested, then there's nothing to say that you must still fulfill the requirements of Part 28, in that these documents must be proven to be relevant and they must be proven to be, to meet the remainder of the criteria under Part 28. But if your submission at the moment is about these documents weren't requested in the past, and for this reason they should not be requested now because the date for which they should have been requested was, say, August last year, and now we're in, May 2022, a few months before trial, then I don't buy that, on the basis that eventually, to support your claim, you still need to produce them. So are you making submissions on relevance at the moment? Are you making submissions on the basis? Yeah.
I apologise for not being clear. What I'm trying to do is deal with some of the principal points before we delve into the detail, but I should make absolutely clear at this stage, my client's firm position is that she has disclosed all of the documents necessary to evidence and support her claim, and that some of the requests that are made are for documents that they already have and that are easily identifiable in the disclosure. And so I don't accept, and I should make very clear that I don't accept the suggestion that my client has failed to comply with her disclosure obligations, or that relevant documents haven't been produced already. What I was dealing with in that submission was the request for further documents in some of the requests, like the request for example, constitutional documents of the entertainer or date holdings or whatever. But this is going to have to be a point that we make on a line-by-line basis. But in short, it's both. Most of the requests are requests for information that is in the disclosure. And I should say that the vast majority of documents in the disclosure universe are documents disclosed by the claimants. There is an absolute paucity of documents disclosed by the claimants. So my client has disclosed all of the documents that she intends to rely on, and a number of the requests ask for information that is contained in that disclosure. And the narrative surrounding those documents is obviously something that would be, and in fact is, in draft, waiting to be served in the witness statement prepared for trial, where all of these points would be canvassed. And so we do object to being effectively asked to do the same job twice. But perhaps I should come on to that. I think my learned friend made some points about the law. If I can deal with the law briefly, then I think the most productive thing is going to be for us to just go line by line through the requests, painful though that is. So rather than digging in and out of authorities bundle, I think it's probably easier just to have my skeleton argument to hand, if you might. It's beginning at paragraph 24 of my skeleton. So point number one on the requirement for an RFI to be concise, we put in the skeleton by way of example the Berezovsky-Abramovich case. Now that's for Madam Registrar's note, a $5 billion fraud claim, in which the court held in that case that an RFI of 50 requests, even in litigation of that value and complexity, ought to be relatively uncommon, and that an application which pores over the detail of evaluating each of 50 requests, giving reasons why each should be allowed or refused, should be very rare indeed. It's not appropriate to make an RFI that delves into that level of minute detail, and yet in my submission that's exactly what we have here, in a dispute that, whilst important to both of our clients, I'm sure, is not of that value and complexity. So we say on its face the RFI is plainly disproportionate. And then really the sort of nub of my submission is this, that if you're seeking clarification of a pleading, that ought to be made at the earliest possible opportunity. It ought usually to be made promptly upon service of that relevant pleading. And that is so that any dispute can be resolved preferably at the first CMC, so that disclosure and document production is ordered on the basis of settled statements of case, rather than statements of case shifting around. And delay, we say, is clearly relevant to your discretion to order information. In the Georgia Corporation case, which my learned friend's already taken you to, there was a delay of about 3 weeks, and that was held not to be egregious. But here we're saying there's a delay of over a year and a clear disruption already of the procedural timetable when we're getting, you know, perilously close to trial preparation. And so we say that is a delay that ought to bar the application. Now you've looked at paragraph 28. Here we deal with the dispute between my learned friend and I as to exactly how detailed the pleadings need to be in order to enable the claimants to understand the case. The Dayar development case, the court gives guidance, and I've set out the quote there. I don't think there's a dispute between my learned friend and I that obviously there's a balance that has to be struck. There's obviously the pleadings need to give fair notice of what the claim is. And the purpose of the pleading is to enable the opposite party to know what case is being made in sufficient detail to enable that party to prepare property to answer it. But the idea is not to have delay and interlocutory battles in which the parties in the court pore over endless pages of pleadings to see whether a point has or has not been raised. The idea is to raise the point. The idea is not to provide endless pages of particulars about each and every detailed point. That is the purpose of witness statements. It's clearly the point of witness statements to provide the facts in support of the allegation. The pleading makes the allegation and the witness statement provides the facts in support. And at the close of that quotation, what is important is that the pleadings should make clear the general nature of the case of the pleader. This is true both under the old rules and the new rules. And I just pause there to make an observation about the nature of this case. And it's something that was canvassed in front of Justice Giles in the document production disputes. This is a case that makes allegations that the defendant obviously instructed the claimants to assist her with the sale of the business. They had leading roles in the companies. They were involved in the sale process. That's not in dispute. But what is in dispute is the extent to which they, behind the defendant's back, as it were, engaged in their own secret plot, management buyout. And so there's a key aspect of the dispute is what did the claimants do behind closed doors? Now that, as Justice Giles fairly acknowledged in the document production order in 31st of August, that's a factual case where there is an asymmetry of information and the defendant doesn't know what the defendant did behind closed doors. And it's that sort of case where uniquely the disclosure and the factual evidence are going to be important in establishing those facts. It's a case where the defendant is at an information barrier. And so we say it's particularly acute that in that sort of case, all that one can do at the pleading stage is lay out the general parameters of the allegation, but it's abundantly clear that it's going to be necessary for disclosure and document production, and then the witness statements which put the narrative on that disclosure. That will be the phase of the litigation, if I can put it that way, where the case is fully fleshed out. And so for your reference, in terms of those orders of Justice Giles, it's paragraph, sorry, I'm just scrolling down my notes, page W. I've got a reference to the X bundle, which I told you I was going to try and avoid. So I'm just going to try and find you a reference in the W bundle.
It doesn't actually matter. I don't
Fine.
think, Ms. Hurst, because I think that I can, regardless of where the page is, I still have to
the point is
the bundle
simply
again.
that this is a point that was grappled with Justice Giles in the disclosure phase, where he recognised that in this kind of case, uniquely, the defendant is at an information disadvantage. He obviously looked at that pleading. There was no suggestion that the pleading was deficient or that it didn't give sufficient notice to the claimants as to the case that was being made, but he recognised that obviously in that kind of a case, disclosure is particularly important to flesh out the allegations. And so if I can just jump back into my skeleton, paragraph 29, we've cited again the Cengiz and the Tijani case about, again, this difference between what needs to be in a pleading, what needs to be in evidence. If I could just briefly look at the quote from Tijani in paragraph 30. It's important that parties properly distinguish between concise statements of facts and recitation of the evidence upon which they seek to prove such facts. otherwise there's going to be increasing prolixity in pleadings. And so there's clearly a balance to be struck. One doesn't plead evidence, that's very clear. We don't list out all of the documents or so on to be relied upon. It's a general statement making the allegations clear that, of course, will be supplemented by witness evidence. And then this was what we say was explicitly recognised in the context of a Part 19 application in the Georgia Corporation case. Justice Giles explained, obviously, that Part 19 is materially the same as Part 18, and it was intended to replace the regimes of interrogatories and further and better particulars. And so I don't quite understand my learned friend's submission that there is a material difference to be made between an application for interrogatories and an application for further and better particulars. We don't have those anymore. We just have the Part 19 regime. But in either regard, he emphasised in Georgia Corporation that the test of necessity is a stringent test. It's not going to be necessary to provide further information if that information is going to be given in another way. And he notes in that regard the quotation from in the National Grid case from the judgment of Lord Wolfe in Hall and Sevelco. Necessity is a stringent test. It cannot be necessary to obtain information or admissions which are or are likely to be contained in pleadings, medical reports, discoverable documents, or witness statements, unless exceptionally a clear litigious purpose will be served by obtaining the information on affidavit. And he emphasises the importance of the word prepare in that test. The word prepare is important. No doubt it can extend to obtaining an admission to be used in the party's case. But it indicates a process which can also be satisfied by calling evidence of the matter the subject of the desired admission or Part 19 request. Necessity and proportionality must take account of other sources and ability to provide other evidence. And so we say that it's plain on the face of that authority that if you are about to be served with a witness statement that goes substantially through all of the disclosure and makes the party's case, then it's not appropriate to order an RDC Part 19 request to be responded to, which is going to traverse materially the same ground, particularly where, as I say in this case, it's so wide-ranging, 51 requests going through substantially all of the pleading. And where what's being asked for is, well, give us particulars of this, give us particulars of that, set out what documents you say are the confidential information, what documents you say are the investor presentations. All of that's going to come in the witness statement. And Justice Giles makes quite clear that it's not necessary to order the information if it's going to come in a witness statement. And so we say that's almost a complete answer to the requests that are made by the claimants here. And there are further authorities there. Perhaps I would just pause on paragraph 34 in the Hall and Sevelco case again. It's going to be premature, that case makes clear, it's going to be premature to make an order under Part 19 unless it cannot reasonably be expected that the information is going to emerge from discovery or witness statements. And again, it's my client's case that the documents are there. If the claimants have failed to identify them themselves in the discovery, then the defendant will do that job, going through the disclosure and identifying the documents on which he relies in the witness statement. And so this request is premature. And so I think with that overview, I'm afraid I can't avoid going through the requests line by line, because we say that they're just not warranted with that test in mind. So I've got a separate tab open with the requests at it's 386 W386, I think. I say that I thought I had a separate tab open and I think I might have clicked on something else. So I apologise, I'm just going to get those up again. It really is unfortunate that we don't have these easily accessible.
Is it possible for that to be extracted and sent to me separately by email or to the registry? And that way what I can do is cross-reference.
I'm sure someone sitting behind me would be able to do that. My multitasking wouldn't extend to that, I'm afraid, Madam Registrar, but I will ask my instructing solicitors to do that for you.
Yes, if they can do that, that would be fantastic. Thank you. And then the registry can forward me a copy of the requests. Shall we briefly adjourn for 10 minutes while we do that?
By all means.
Fantastic. So let's come back at 12 p.m. Dubai time, 10 minutes from now.
Thank you.
Thank you. Thank you, Ms. Stewart.
Sorry. I didn't realise I was on mute when Ms. Hurst was speaking. At Annex B of my skeleton, each and every request is actually set out.
Okay.
Thank you. I'm grateful.
Thank you very much.
I've got the separate document that's been emailed through. If we can, well, we'll start at the beginning with request 1. This, we're told, relates substantially to paragraph 33 of the amended defence and counterclaim, which you were taken to. And this goes to the point that I was making earlier. This is, of course, the kind of case where there is an information barrier if the defendant is alleging that there's a secret plot. But in my submission, paragraph 33 is a perfectly proper pleading. I'm not responsible for the document, but it's a perfectly proper pleading. The nature of what the allegations, the broad allegations, are set out there. And it's clear that what's being alleged is that there was a proposed MBO, that the claimants went behind the defendant's back, disclosed confidential information and caused loss as a result. The parameters of that dispute are clearly set out and understandable. And just in relation to the response to that pleading, I'd like to turn up the claimant's reply. That's at page W57 or page W69. 57 is the first claimant, 69 is the second claimant. They're in identical terms, but what you see at paragraph 2.35 of the reply is just simply paragraph 33 of the defence is denied. The defendant is put to strict proof of these allegations. And so I emphasise there's no complaint saying, well, hang on a minute, what on earth are you talking about? We don't understand what you mean by secret plot. We don't understand what you mean by MBO. Who are these third parties? Who are these investors? What are these presentations? What's this confidential information? It simply said that the defendant is put to proof, as one would expect. So the broad parameters of the allegation have been stated, they've been understood, and the defendant's been put to proof. But in case there was any doubt that the claimants have understood what was being said, as I made clear in my sort of overview submissions, the claimants have substantively engaged with these allegations. They've substantively engaged with what's meant by MBO between the parties, why it's relevant to these proceedings, who the third-party investors are, because they dedicated a whole section of their first affidavits to dealing with this. And if we can go perhaps to the second claimant's first affidavit of December 2021, it's tab 27 of section W, and I'm looking at page 388.
I think I've got the wrong tab here, Ms. Hurst. Sorry, just bear with me, please.
No problem. It's if you're in W, it's tab 27, and the document begins at page 884. Sorry, I may have said 388. I meant 888. That's my eyesight, I'm afraid, and not your mistake.
Which is the first affidavit of
Paul Patrick Hennessy.
Yes, of the second claimant.
Yes, and this is the affidavit that was given.
W888. Sorry.
Yes, I do apologise. That's just me going slightly cross-eyed, I'm afraid, and reading a 3 is an 8. Sorry about that. So the document begins at page 884, and I'm looking down on page 88. Well, actually, let's begin at the bottom of page W887. And there's a heading here: the defendant's awareness of the aborted MBO efforts, no quote-unquote secret plot. And I just invite you perhaps to skim read, if you could, Madam Registrar, what's being said here. There's a clear reference in paragraph 16C, paragraph 33 of the amended defence and counterclaim. So that's the part of the pleading that is said to be so hopelessly unclear that the claimants don't understand what's going on. And what's being said here is that I don't understand why there's a secret plot, because effectively, and this is what's said in 17 onwards, everything was disclosed and above board. That's the nature of the defence that's being put forward. And so we see here paragraph 17, commencement of MBO discussions. In early 2017, following the failure of a professional investment intermediary to find an investor, the claimants suggested that they should consider the option of a management team acquiring the entertainer through an MBO, and on and on. Now, I don't want to labour the point, but if one looks over the page to, if you have hopefully now in front of you the requests, you know, we're asked by request 1F, what's the defendant's understanding of the term MBO? Well, it's abundantly clear that all the parties know what an MBO is. They're sophisticated parties. This is a dispute about the sale of a business. Everybody is using the phrase MBO as a defined term without any difficulty understanding what's going on. It's then said, request 1C, for example, well, who on earth are these proposed third-party investors? We just don't understand. Well, look, paragraph 20, discussions with Panmure Gordon. Paragraph 22, discussions with Mayfair. Paragraph 24, discussions with GFH. Well, again, it's clear that the claimants know who were the potential purchasers of the entertainer at the time. This goes in detail through what the claimants say is their version of events. Again, request 1D, meetings with third-party investors. Request B, who are these third parties? How is this alleged? What I'm saying is, in broad terms, it's clear from this affidavit that's being given that, far from looking at paragraph 33 and saying, oh my goodness, what on earth is this all about? Not a clue. That the claimants have grasped the essential nature of the allegation that is being made, and they are engaging with it. Now, of course, they don't agree. They don't accept that there was a secret plot. They don't accept that they disclosed confidential information to third-party investors. That's why we're having a trial about it. But to say that they don't understand what's being alleged, and that it's so hopelessly unclear that my client needs to be put to the time and expense of going painstakingly through requests A to G little Roman 3 here, we say is clearly wrong. It's clearly not necessary. They clearly understand what the allegations are that are being made. And just by way of final example, looking at 1G, well, what does substantial free equity mean? You know, I emphasize again, these are sophisticated parties. These are sophisticated individuals, the CEO and the CFO of, and the defendant as the shareholder. They understand full well what they mean when they're using these sort of M&A terms of art, and you can see that in paragraph 29, 30, where here Mr. Hennessy is describing the end of MBO efforts. He's describing here the terms of an aborted MBO was simply that the management team would roll over 50% cash payments in exchange for equity. Post-management acquisition incentives remain to be negotiated. You know, it's not. This isn't a scenario where these terms are not understood. The claimants know what these mean, even if they've, or at least they did in December, even if they now claim not to understand. And just in terms of the point that I made earlier about documents, my learned friend herself took you to a number of documents which relate to the MBO. She showed you the indicative offer to support an MBO. She took you to a revised offer. She took you to the term sheet of September 2017 from Linklaters. Now, I emphasise these are all documents that the defendant disclosed, that they are there in the disclosure universe. All of the documents which support the allegations in paragraph 33 are in the disclosure universe. And when her witness statement is served, she will serve the narrative that tracks along those documents and that explains the extent to which she says the MBO was not fully disclosed as described in this affidavit. But what we seem to have is a situation where just because the claimants disagree with the allegations, they claim not to understand them. We say that's not right. Finally, in relation to this paragraph, I would, it's been pointed out by those behind me that in the letter before claim, or in the response to the letter before claim, again, details of the confidential information and so on were set out and clearly in the narrative. That's in the X bundle at page 36, but in the interest of time, I'm not going to go to it. And I mentioned earlier, again, it's reflected in the order that Justice Giles made in January, the page reference for that is, I'm afraid, again, in the X bundle.
Could I just ask,
tab 10.
did you just say that was X36, the letter before?
I believe so. I hope so. If that's not a right reference, then I'll come back to that. If I can just, again, very briefly, I'll read it out, Madam Registrar, if you don't have access to the X bundle, but it's at page X113 for my learned friend's note.
I think I can pull it up. Just bear with me, please, Ms. Hurst. X113.
Yes.
Yes, I have it here. Thank you very much.
But I just want to sort of briefly point out paragraphs 3 and 4, which is a very broad brush summary of the dispute, which obviously Justice Giles has arrived at this summary having read 2 sets of detailed affidavits from both sides, including the extract that I just showed you, which is a brief part of the evidence that was before him. And again, he says, sort of reading through paragraph 3, sorry, I just want to check, Miss Stewart, are you still there? You've turned your camera off, but I just want to check that you've not dropped off.
No, I'm still here.
Fine, no, okay, I'm just checking that we didn't have any technical issues. Again, the defence of the claim includes allegations that the claimants were in breach of various duties by reason of an illicit attempted management buyout. It's alleged that in the course of the MBO, they engaged the assistance of a Mr. Atkinson. They charged expenses to the entertainer's corporate credit card and disclosed confidential information to third-party investors, etc. Paragraph 4, it's not in dispute that there was an abortive MBO, but there appears to be a dispute over whether it was illicit or kept secret from the defendant. In general terms, the 11 categories of documents are directed to what the claimants did towards the MBO, and in particular their communications between themselves, Mr. Atkinson and Mr. Ashford. It's evident that document production is an important tool in the defendant establishing their activities, on her case otherwise unknown to her, which is the point I was making earlier about the sort of information gap. And so, in broad terms, we have disclosed a large number of documents which were gleaned from the entertained server, which we say go to establishing our claim, and those will be traversed in the witness evidence. The point of the document production contested application was that there were allegations that it appeared that there were further documents that hadn't been disclosed that must have been passing between the claimants and these individuals. And that's what was being discussed there. But the wider point here is that through that exercise, that painful exercise of the last 5 months, it was quite clear that both parties knew what was being alleged. They knew what was being said about the MBO. And in many cases, and we'll come on to this when we look at some of the other requests, in many cases, the claimants averred that the relevant documents had already been disclosed. And so to now suggest that the basic allegation is not understood, we say is surprising, to say the least. And that goes equally, Madam Registrar, for request 2. I'm going to try and be briefer going through the rest of the request, because I think you have the sort of broad parameters of my client's complaint. Request 2 is a request for investor presentations. Please clarify whether these investor presentations were prepared or whether they were actually presented. Who were they, when were they given, etc. And we say again, in the evidence that I just showed you from Mr. Hennessy, we already saw reference to presentations being given to investors. So it's quite clear that he understands at least what was being alleged there. And it's perhaps seen more clearly in the second affidavit, which was relating to specific documents, which is at W tab 32, I hope. I really should have these references in a slightly larger font, I'm afraid. I think that's a 3 and not an 8. The tab 32, page 10, the affidavit begins on page 1026, but it's at page 1033 that I'm interested in. Sorry, paragraph 1032, in fact.
W1033?
W1032.
1032. Okay.
Yeah, which is the beginning of paragraph 8.
Yes, verification.
Now, this was an affidavit that was given resisting an application to disclose specific documents. And you can see 8A there, there's a reference to a particular document that's being given. There was a list of, I think, 8 documents that had been identified as being referred to in another document that we hadn't found in the claimant's disclosure. And here, the claimants positively aver that all of the presentations have actually already been disclosed. So he says the document attached here, if one looks at 8A3, the actual presentation made by the management team to the third-party investors is included in folder 4 of the defendant's standard production of documents, items 7 to 10 of, and there's an exhibit there, as explained further in paragraph 8E below. Goes on to say this email that's being discussed, where we thought there was a reference to another document. Here, the attachment referred to is an earlier draft of the management team's presentation to potential investors. Hi, David, please see attached PDF draft. File size is too large, blah, blah, blah. It is clear that this document that's being referred to here, where disclosure is being sought, is a draft document that's not sufficiently relevant or material to the defendant's pleaded case, that the first claimant and I unlawfully disclosed confidential information to third-party investors. Therefore, I object to the production of this document as the final presentation, and his case is that this is a draft. The final presentation has already been produced. And so again, we find it surprising, to say the least, that request 2 pops up saying, well, what on earth are these investor presentations? Were they ever given? Who prepared them? What's going on? Because we've engaged at a very granular level of detail here with the documents that have been produced, the presentations that have been given, and we've had detailed submissions here about whether a draft document, a draft presentation, should also be produced in the disclosure. So quite how the claimants can come to court now and say, well, what do you mean? What are you saying when you say we gave investor presentations? We say it just sort of flies in the face of their previous evidence. Request 3, again, I think I can take this fairly briefly. It seems to be a confusion as to what the word such means in the pleading, whether that's a reference back to the allegations in the previous paragraphs. I can confirm, yes, it is, and don't think there seems, so insofar as this seems to request, well, it says 3A, insofar as not already covered in responses to questions 1 to 2 above, well, I think we say that they are already covered. And for the same reasons as the claimants aren't entitled to a response to requests 1 to 2, they're not entitled to a response under request 3. Request 4, again, full and proper particulars of the confidential information referred to, that's duplicative of what we've already looked at in regards to request 1. It's not clear to me why this is being separately referred to when it seems squarely to duplicate what was being asked for in request 1A, but anyway, you have my submissions on that. Request 5, I'm not sure whether this was covered in detail by my learned friend, forgive me if it was. We don't really understand the basis of the request because it's not pleaded by the defendant or the claimant that the confidential information was obtained during the due diligence phase. It's pleaded by the defendant that it was disclosed secretly behind the defendant's back. So we don't understand how this is a request to clarify the pleading when this isn't alleged in the pleading. And neither have the claimants pleaded this as a case. This doesn't form any part of their case either, that GFH obtained the information during the due diligence phase. So we don't really understand the relevance of it. And so therefore it can't be shown to be strictly confined to what is necessary to understand the defendant's case. Very simply, it's not the defendant's case. And so that's that. Likewise, request 6 appears to be a duplicate of request 5, asking for full particulars of the confidential information in the due diligence phase. We don't understand what that's about. I'm trying to sort of be as brief as I can
I
because
can actually explain to the registrar these points. Perhaps you didn't hear. It was about the asymmetry of information. Well, I can come back on it later.
But thank you. I didn't interrupt you, Ms. Stewart, during quite extensive submissions, so I'd be grateful if you didn't interrupt me.
I'll give you an opportunity, Ms. Stewart, to comment in reply after Ms. Hurst wraps up her submissions. Thank you.
So request 8, please provide a summary of the nature and dates of all the steps taken by the defendant and RED to sell all or part of their shareholdings, irrespective of whether such steps were taken related to the competitive tender process or not. And here my submission is simply, this is an extremely broad request in circumstances where it's not in dispute. I don't think, I'll be corrected. It's not in dispute that the defendant was trying to sell her shareholding. And it's not in dispute that a number of steps were clearly, plainly and openly taken in respect of that. The AD amended defence and counterclaim already pleads in detail what steps were taken to sell the shareholding. And you'll recall a few minutes ago I showed you Paul Hennessy's affidavit, which was on page 888, not 388. We can go back there briefly if you like, but that's the reference. Paragraph 17 of that affidavit explained that there was a professional investment intermediary instructed, the Rain Group. They'd failed to find an investor, and it was off the back of that that an IPO was being considered, and the claimants also suggested that they would do their MBO. That's paragraph 17 of the claimant's own evidence. So now to have this request that says, please provide a summary of every single step that was taken at any stage by the defendant to sell all or part of their shareholdings. Well, that's A, extremely broad, B, doesn't seem to even be in dispute, but C, the claimants have shown in their evidence that they know full well what was being done by the defendant to sell her shares because they were involved in it as officers of the relevant company. And it would be utterly disproportionately burdensome for the defendant to list out all of that evidence that doesn't really go to an issue in the case, every single step, every communication with every potential purchaser. Even the brief overview that was given by Mr. Hennessy ran to several paragraphs of evidence. We cannot see why that's necessary or proportionate under RDC 19.6. Given that there's no dispute about what was going on with other investors, there's a dispute about what was told to GFH. And we say that's clear on the face of the pleadings. Again, request 9, this seems to overlap with request 8, insofar as not covered in the previous question. The methods by which potential investors were approached, all indicative offers, all binding offers, and the reasons why GFH was selected as the winning bidder. We already have my submissions on why all of the steps and all of the communications don't need to be given. But it does bear emphasis that there are about 200 documents in the disclosure which cover communications with potential investors. They include PowerPoint presentations, letters to and from third-party investors, and we have disclosed the relevant agreements. We've disclosed the SPA and the documents, the communications, the open communications with GFH. So all of those documents have already been given. Insofar as they want even more documents about communications with other investors, I've already said it wasn't requested at the relevant time, the request to produce time, and it would be utterly disproportionate to ask for those documents now, when the documents relating to GFH's purchase have already been disclosed. They're there in the document production. And insofar as the claimant doesn't understand them or doesn't understand the relevance of them, and of course, my submission is that the witness evidence will amply cover this. Donna's witness statement will go through in detail the communications with GFH that she had on an open basis, and provide the narrative to the disclosed documents. And so it's not concise, it's not proportionate, and it's not necessary because the documents are already there. Now, request 10. Sorry, I'm trying to be, I'll be quicker. I'll try and give you one line rather than several. Request 10, again, this is something that will be covered in the witness statement. It's also clear, you'd have seen from the case management order that there is provision for expert evidence in this case. which will obviously go to valuation and quantum, and it's absolutely standard that in this sort of business sale dispute, the quantum of the claimant's case, and in this respect, the defendant is the claimant in the counterclaim. It's standard for that sort of issue to be covered by expert evidence. So again, this is a matter we say for the evidence and not for the pleading. Request 11. Again, this is a matter for the factual evidence, as I've just said. There's no defect in the pleading. The allegation is clear that the value of the sale was impacted. The terms and the value of the business sale have been disclosed in the documents, and the extent to which they're negatively impacted, again, will be a matter of valuation evidence. And as I showed you at the time, by way of reminder, paragraph 33.1.1, which deals with this, the defendant will quantify the loss of value at the appropriate stage, given that the relevant evidentiary documents are likely to still be in the possession of the claimant and following submission of witness evidence and expert reports. So the claimants were put on notice that this could be something in respect of which there may be valuation evidence and that would need to be fleshed out following disclosure. And the claimants took no issue with that. They simply put the defendant to proof. And we will prove it, but it's not a matter that needs to be pleaded. Request 12 seems to be a duplicate of request 3, so we've already addressed that. Request 13, full and proper particulars of when they became aware that the claimants tried to conduct acquire the entertainer through an MBO. Again, this seems to duplicate matters we've already looked at in request 1. But I've already shown you Paul Hennessy's evidence, page W888 again. His evidence was that in early 2017, I proposed to the defendant in an in-person meeting in her office that in addition to an IPO, we should also consider the option as a management team acquiring the entertainer through an MBO. The defendant instructed me to prepare a presentation on the MBO option for discussion at the next board meeting. Now, the defendant doesn't accept that everything that happened thereafter, that the defendant doesn't accept that it was properly disclosed to her that they carried on to pursue an MBO. That's where the dispute lies, but there's no dispute, as far as I'm aware, that...
Sorry, Ms. Hurst, I didn't hear you there. Could you just repeat what you just said?
Certainly, I was quoting from Mr. Hennessy's evidence at paragraph 17, and where he says that in early 2017, he proposed to the defendant an in-person meeting in her office. And I said that the defendant doesn't accept everything that's said in there. It's certainly not accepted that there was a presentation given to the board and that approval was given for an MBO. But there's no dispute between the parties that the issue was raised in early 2017. So we don't understand that request 13 goes to an issue in dispute. The parties are clearly aware what the relevant time frame was. Request 14, full particulars of the alleged failure to disclose a conflict of interest. Well, we say that's, again, clear on the pleading. Paragraph 33.4 and 33.6 makes clear that obviously the claimants owed fiduciary duties to the company. And so if and to the extent that they were pursuing their own interests and not the interests of the company, then that was a conflict of interest. And it doesn't seem to be alleged by the claimants anywhere in their pleading that they turned up to the company and said, yes, by the way, we're trying to, we're engaging in a secret plot contrary to our fiduciary duties. So it's a standard plea of non-disclosure of conflict of interest.
But Ms. Hurst, I guess on this point, and this is probably one of the points that I'm sold on the claimant side, it's very difficult to map where the claimants went wrong and how this secret plot is being alleged. There's no parameters of how this came about, given that the evidence that Ms. Stewart showed me pointed to the fact that the defendant was very well aware of the MBO. So I think it would be helpful to have some detail about the allegation that's being raised here in the particulars, just to map out what's gone wrong and where the conflict of interest actually lays. Yes, there is obviously fiduciary duties owed by the
Well, I think-
claimant to the defendant. Sorry, I'll quickly finish. And
No,
then
no,
I'll
I
let you speak.
apologise.
Yeah.
I thought you finished. Apologise.
No, that's okay. So there's obviously fiduciary duties owed by, you know, I won't call them officers and I won't call them directors because obviously there's conflict as to whether they are identified as directors or officers, but the CEO and the COO, yes, they do owe fiduciary duties to the company. But insofar as I can see, the MBO was announced to Miss Benton. It was, and Miss Stewart took us to that very evidence. She was in the know. So yes, I do find that detail to be quite important.
I suppose there are 2 points. There's the underlying factual point and then there's the legal point, which seems to be asked by request 14. As to the underlying factual point, what the claimants are saying in Mr. Hennessy's affidavit is that there was a meeting where they suggested that they might pursue an MBO. They were told to go away and prepare a presentation. And then the defendant's case is that nothing came of that. There was no further discussion. There was no authorization from the board to pursue an MBO. And that thereafter, the defendant and the shareholders, so far as they were aware, the claimants were pursuing third-party investment, that there wasn't an MBO on the cards at all. Now, of course, I accept that's disputed, but I'm not here to prove the defendant's case. What I'm saying is that is what is alleged. The defence says, you didn't have authorization to do this. The defendants say, yes, we did. Now, you've seen some of the documents. You haven't been shown all of the documents that go to this. But the extent to which the defendant says, well, actually, you carried on doing this when you didn't have authorization. Well, firstly, one, you didn't have authorization. That's something that we'll have to prove. But that's alleged. That's already alleged in paragraph 33. We say there was a secret plot. You weren't authorized to do this MBO. The way in which that MBO was carried on, we will have to prove. We will have to prove that the defendant was not aware. The defendants the defendants of the counterclaim, the claimants, I should be clear, will lead their own evidence saying this was perfectly approved, you knew exactly what was going on, and here's the documents that show it. That's all well and good, but that is plainly, in my submission, a matter for evidence. It can only be a matter for evidence. We need detailed commentary on the documents. The defendant will have to give evidence in her own words about what she did and didn't know, and no doubt Ms. Stewart will cross-examine her on that. But in my submission, that's plainly an issue for evidence. It's not an issue for the pleading. And coming back to request 14, which I think was the second point that you raised about this conflict of interest, it is, I hesitate to use the words sort of trite, but as a matter of fiduciary law, if they owed fiduciary duties and they weren't acting in the defendant's best interest but pursuing their own interest, that's clearly that's the sort of archetypal conflict of interest breach of fiduciary duty scenario. We say that is adequately pleaded in paragraph 33.4 and 33.6. We allege that fiduciary duties were owed, and we allege that they were breached because this conflict, this pursuit of self-interest rather than pursuit of the company's interest, the shareholders' interest, was not disclosed. It all tied in with the secret plot.
Just bear with me, Ms. Hurst. I want to go to those paragraphs, because I think it would be helpful just to read through them. So the amended defence and counterclaim, and you said paragraphs 33 and 34.
Yes, let me also bring that up. I'm sorry, I'm looking at a different document right now.
Thank you. I think I'm on W15 to 40. So I think the relevant page number might be W28, if I'm not wrong.
Right, yes, I'm very grateful for that. Too many tabs open. So paragraph 33, of course, we've looked at this a number of times. You can see the sort of heading, if you like, or the sort of introductory wording of paragraph 33 is that this was a breach of duty, including the squarely alleged breach of fiduciary duties owed to the co-shareholders by 33.1 sharing the confidential information, and the full particulars are given there. again, including by reference to the relevant law. And perhaps actually while we're looking at this, I might just pick this up really briefly. It's a response to a separate request. But there's a request made, and let me get the number right. Request 20, which is, we don't understand why you're referring to the UAE CCL. Quite simply, that's because that's the governing law of the employment agreements. And I can give you a reference for that. It's on page, well, the agreements are at page W297 and the relevant clauses at page W312. But that's obviously a matter for legal submission in due course. It's not a matter of clarification of the pleading. If the claimants want to say that those are not the right laws, that those laws don't apply, they're very welcome to do that in submissions. It's not a matter that we need to have an RFI about. And then again, paragraph 33.3, scrolling down, another alleged breach of fiduciary duty or breach of duty, setting up the SPV, using the trademarks, etc., without being authorised. And then paragraph 33.4, which I think is the nub of this conflict of interest point. There's a serious conflict of interest in their ongoing engagements by failing to inform the defendant or the alternative, the board of directors of the entertainer and or date holdings of their intention to acquire through an MBO. They were, on the one hand, aligned with the proposed investors in seeking to, i.e. their proposed investors in seeking to obtain the best price and terms for their acquisition of the entertainer, I apologise. Yet, on the other hand, they were part of the entertainer's internal transaction team dealing with and attempting to secure a business sale on the best terms available to the defendant from Red Entertainer as sellers. So it's the wearing of double hats that we say is properly and squarely pleaded here, that if you're the CEO, CFO of the company, and you owe fiduciary duties to that company, and you're part of that company's internal transaction team who is dealing with the outside investors, trying to sell the shares and get the best possible price for the shares for the shareholders, then it's a conflict of interest if you also have an undisclosed plot to do an MBO where you're having a side channel with the investors and you're talking to them and you're disclosing information that they wouldn't otherwise have access to. And we say that's all properly and squarely pleaded out in paragraph 33. But that's what the conflict of interest is. The extent
I don't
to which
think you're wrong. I don't think you're wrong, Ms. Hurst. I think we're kind of at a cross lines where the claimants have an account and the defendant has an account. And I think the issue that we're having is that the level of detail that the claimant expects at this stage, obviously, is that there should be a lot more detail in terms of when you came to be aware of the MBO, why did you think that the MBO was not properly disclosed to Ms. Benton, for example? And I think that everything that you say is correct, but the particulars at this stage of the amended defence and counterclaim don't quite reflect the story that unfolded. I think you will get there, but just reading 33.4 cold, obviously it's very, very clear that there is a conflict of interest, that there could be a conflict of interest. It's very, very clear that there could be a breach of fiduciary duty. But against the backdrop that Ms. Stewart took me to, it's difficult to see how this can be claimed at this stage. Yeah, sorry. Carry on.
Well, I agree that this is an overview, but if I come back to the paragraphs of Justice Giles's judgment that I took you to, we don't need to look back at that. But the parties know what the parameters of the dispute are. The dispute is: was this MBO properly disclosed? Was its ongoing pursuit properly disclosed? Was the defendant aware? And then, of course, as a corollary of that, if not, is that a relevant breach of duty? Is that and did it cause loss? Those are legal points, obviously, but the factual points, as Justice Giles squarely recognised, the broad parameters are there. The document production and the evidence is where the detail of that comes out, necessarily has to come out, because I can't make good my client's case without taking you to the documents, without showing you her witness statement. And the irony of this, Madam Registrar, is that that witness statement would have been filed a day after this application was made. Detailed work has been done by the defendant to go through the disclosure, to set out her narrative, to put her understanding, to join the dots and to say, look, this is what you told me, this is what you didn't tell me, and this is what the documents say. Now, that is obviously, in my submission, a matter of evidence. It's not a matter for the pleading. The pleading makes the allegations, it makes them squarely, it makes them fairly. We've been put to proof on them, and we will, or we won't, according to what the court determines, but we will attempt to prove them. We have done the detailed work of going through the disclosure and preparing the witness evidence. And on the point of being ready to file that witness evidence, we're instead faced with a wide-ranging RFI asking for the very things that either asking for documents that are already identified in the disclosure, or asking for points of factual detail which we are ready to provide them in the form of a witness statement. But what we say is utterly disproportionate is to require us to do that twice. Why should we sit and go through 51, and I did count them, 51 sub-requests for little points of detail, minute points of clarification, or to set out here what documents here, what documents there, when we are about to exchange witness statements. And there's another point, and in my submission, it's a procedural fairness point here, because the case management order is not for sequential exchange of witness statements. It doesn't say, okay, why doesn't the defendant set out her understanding and why don't the claimants respond to that? It says, no, there will be contemporaneous exchange of witness statements. And the claimant's case has been all along that this was fully disclosed. There was no disclosure of confidential information. There is absolutely nothing to see here. And so if that's the case, one wonders why they need to see the claimant's witness evidence first. And it will be witness evidence in order to respond to all of these requests. One wonders why they need to see the defendant's witness evidence in order to respond when their case is black and white. There was nothing undisclosed to you, and we didn't disclose confidential information. Well, if it's that stark, then they don't need the defendant's evidence in order to say that. But they will get the defendant's evidence. They don't need this as well. I'll be very, very brief and just dealing with the final few requests. Request 15 is asking about provisions of Cayman law, which are set out at paragraph 28.2. And then it says that, well, that doesn't say provisions, it says principles, please provide the provisions. Well, I'm not quite sure what the point is. It seems to be semantics, but the provisions are the principles, are the provisions. They're the same thing. The points of Cayman law that we rely on are set out at paragraph 28.2. They're, I'm sure, recognisable to you, Madam Registrar. They're standard common law fiduciary principles. They're well known in the DIFC law too, in the Companies Law, Law 5 of 2018. And in fact, I should note that there's no suggestion from either party that expert evidence is required as to Cayman law, which would ordinarily be the case, of course. But I think both parties have been content to assume that the fiduciary law of the Cayman Islands is, to all intents and purposes, the same as the fiduciary law of the DIFC. And so neither party has proposed to lead expert evidence on the matter set out at paragraph 28.2. So again, if the question is paragraph 28.2 the four corners of the provisions of Cayman law that you rely on, then the answer is yes. But I don't see that we need to go any further than that. It's a matter for submission in due course. And then requests 16, 18 and 19, I'm going to, apologies, but I'm going to sort of lump them together because this is the request for copies of the constitutional documents of date holdings and the entertainer. And it raises, we say, similar points. Firstly, it doesn't seem to be an allegation that the pleading is in any way unclear or that they don't understand the case. They clearly do understand the case, and the case is that they were office holders and they owed fiduciary duties. Again, to my mind, it's a retrospective disclosure request, and you have my submissions on that as to how late in the day it is to ask for documents. But in any event, the allegation, what's said in the witness statement, in fact, in response to this is, it's alleged that the claimants were officers of the entertainer, which was news to them, and that they're in breach of their duties as officers of the company. And I have to say, we do find that slightly baffling, because it is clearly pleaded at paragraphs 4 and 5 of the defence and counterclaim that the claimants were officers of the company. That's on page W16 that I'm looking at. The first claimant, Mr. Anup Kumar Lal, was employed as CFO by the entertainer, and the dates are given, the role was changed to COO. And the second claimant was the COO and that then was changed to the CEO. And then in response to that, well, those paragraphs are admitted by the claimants in their pleadings. It's paragraph 212 of their replies in each case. And the reference for that is W tab, let me get this right. Let's look at W tab 8, paragraph 212 is on page W65. Simply says there, paragraphs 2 to 12 of the defence on matters of fact and hence no comments. I mean, that's to all intents and purposes an admission of what's contained in paragraphs 2 to 12, including paragraphs 4 and 5 that I've just shown you. So unless someone can assist me, there seems to be no disputed issue that the claimants held those roles. And so it's not clear to us how disclosure of the constitutional documents of the companies goes to clarify any issue in dispute. It doesn't seem to be a dispute, it's admitted. So we say it can't be reasonably necessary or proportionate for us to trawl up all of the constitutional documents. We haven't understood why that could possibly be said to be necessary or proportionate. I think I've covered the remaining requests in my broad submissions. I've covered the request for companies law. Very, very briefly on requests 21, 22 and 23. I can take this very briefly, but it was already requested in the claimant's requests to produce. One of their requests to produce back in August was for information relating to the business sale. And it was dealt with at paragraph 4 of Justice Giles's order on 31st of August. They were ordered to be produced and they were produced. The documents are in the disclosure. There's a document called ESOP calculation spreadsheet. The share purchase agreement is in the disclosure. The Deloitte expert determination is in the disclosure. No complaint has been made that the disclosure is deficient. They were asked for, they were provided. So I can't assist any further other than to say that, of course, the defendant will lead evidence as to the valuation in due course. So, Madam Registrar, I don't want to take up unduly the court's time. You have my submissions. We say that the timing of this request is unfortunate to say the least. This dispute has been on foot for well over a year. These pleadings have been in play for well over a year. They have been substantively engaged with by the claimants through a protracted disclosure dispute, through which several things emerged. One, that the claimants understand full well the allegation that's made against them. 2, that they have engaged with it in affidavit evidence. 3, that not only have they engaged with it, they have gone in detail into the underlying documents that the defendant herself has disclosed. They've pointed to those documents and they've said, well, those are the relevant documents and we don't have anything else, for example, as regards the investor presentations. And so there's been a detailed and granular engagement with these issues. And so now to come to court and say, well, we don't understand and it's all terribly unclear, we say it's just not right and flies in the face of the evidence that they've given. But in any event, if it really was so unclear, the day after this application was filed, the claimants would have received the defendant's witness statement, which sets out in detail the evidence that she leads to support these allegations. And I do say that there's a difference between allegations and evidence, that the amended defence and counterclaim properly pleads the allegations, and that the detail of the allegations is a matter for evidence. That was recognised by Justice Giles. That's why the disclosure was so important in this case, and it's why we had such a detailed argument about it, to make sure that all of the relevant disclosure was before the court. And that disclosure is now going to be dealt with by the defendant in her evidence. There'll be sequential exchange of witness statements, but I do emphasise, of course, the claimants have a right of reply evidence. So if they read Donna's witness statement and think, well, we still don't understand or that's not clear, then they have an opportunity to respond to that. And we did say in response to this application, look, why don't we exchange witness statements? Why don't you read that witness statement? And why don't you tell us if there's anything outstanding after you've read that witness statement that you still don't understand? And that was roundly rejected by the claimants. So we say that they haven't complied with RDC 19.6. This isn't reasonably necessary and proportionate, and it shouldn't be entertained in my submission. And I do finally urge upon you not to engage in a sort of piecemeal, well, maybe this request, maybe not that request, because the totality of the application, we say, has been utterly disproportionate. And the proper course would be to exchange witness statements in the usual way. That's clearly what the authorities say should happen. And then if there is really a problem, then we can engage with it. But at this stage, I urge upon you to reject the application in its entirety. I'm very happy to assist you further, but I'm conscious that we are taking up a lot of the court's time already.
Thank you, Ms. Hurst. Ms. Stewart, I can see you've got some burning comments to make, so.
Actually, could I just have 2 minutes?
Yes, please go ahead. Thank you.
Okay, thank you. I don't know if anyone else is. I don't know if Ms. Hurst's back.
Apologies, I am here. I've just turned my camera off. I'm back. Apologies.
May I begin?
Yes, please go ahead.
Thank you. There have been a lot of words from my learned friends, but with respect, we're still none the wiser. Looking at what was particularly interesting was going through the individual requests. Of course, what should have happened was that the requests should have been answered one by one in the usual way. If we go to for example, potential purchasers and the whole issue of the competitive tender, we're hearing for the very first time that all of the potential purchasers that are relevant to this claim are as set out in the disclosure. Well, why wasn't that said before? We don't know who else the defendant actually spoke to. Why would we? So there's a natural asymmetry of information there. They say investor presentations. Okay, so all they need, we asked about investor presentations, so all they need to say is, these are the particular documents we rely on, X, Y, and Z. Okay, so there are these investor presentations, but we still have absolutely nothing on what it was, what was the confidential information in there that was the causal link to the loss, the alleged loss? We don't know. Now, so that those points simply haven't been addressed clearly and succinctly in a written response as required by Part 19. Now, the particulars of the awareness, on the one hand, it was most confusing listening to it, because on the one hand, my learned friend is saying, well, we were aware, but we weren't aware. And then there's been the acknowledgement of the numerous documents referring to the MBO, but we still don't know exactly what was it that was hidden. If it was confidential information that was disclosed, what confidential information? How exactly did Miss Benton, who's supposedly an experienced business woman, according to Miss Hurst, exactly how did she think that private equity houses were putting indicative bids forward without any information about the company? Where did she think, on what basis did she think that the private equity house was instructing Linklaters to come up with a term sheet with very detailed terms, unless they actually had information? In terms of the fiduciary duty point, of course, a officer, i.e. a director, owes a fiduciary duty to the company. The question that Ms. Hurst did not really get to grips with is in what circumstances a director, if they are a director, can owe a duty to a shareholder of an entirely different company. We heard for the very first time today, and we asked a very simple question. Tell us why the CCL applies. Under the RDC, we're required, the defendant was required to tell us. That's what the RDC says. For the first time today, oh, it's in the employment agreements. Why didn't that just come back in a response? It's very simple. Why is it snuck in at an application with tens of thousands of dirhams being spent? Why not a letter back saying this is the reason? Then we deal with it. My learned friend that says the case on loss is a legal argument. No, it isn't. It's not solely a legal argument. It's also a matter of fact, and we go back again to the causal link. What caused this alleged loss? Now, when we look at the pleading at famous 33, the defendant will quantify the loss of value at the appropriate stage given the relevant evidentiary documents are likely to still be in the possession of the claimant and following submission of witness evidence and expert reports. This is not a matter of quantum, this is a matter of causation that we're talking about. And in my learned friend's submission, she was becoming very confused, I would suggest, or not being clear about the distinction between causation and quantum. Of course, quantum's going to be a matter for experts, But before you even get there, you have to show causation. My learned friend said that because we admit that we had a job title of CEO, COO, somehow that connotes a legal status. A job title of itself doesn't give a legal status. An officer of the company means a director, or under the relevant company law, a manager. We're saying we were neither, except in relation to date for a short period for one of the claimants. But in relation to the entertainer, we were neither. My learned friend spoke a great deal about all the documents we're seeking. In fact, the only documents we're seeking are the constitutional documents that are directly relevant to what duties we owed, our powers, and so on, if we were officers of the company, as they allege on multiple occasions throughout the ADC. In relation to requests 21 to 23, the disclosure request was in relation to consideration. The disclosure request that was made and the information that's been provided does not give the answers to 21 to 23. And if my learned friend believes that they do, perhaps you could point me to the parts of those documents or the quote, other documents that are mentioned by Miss Burt that provide the answers. All we want to know is what we were entitled to and when we should have got it. It's really not, they're really very straightforward questions. Ms. Hurst seems to say that because we engaged at the disclosure phase, therefore we must know the case. That's a non sequitur. We came back and we said, this is what we know, but we don't understand. We don't understand how it's alleged there was a secret plot. There have been accusations that we're somehow trying to derail the procedural timetable. It couldn't be more wrong. If you actually look at the correspondence, we made numerous attempts to accommodate. At W396, paragraph 6, you can say that one can see that we're saying if you need more time, fine. Attached to that letter, we attach a consent order. So, and we offered a further week to allow a response, and we shifted the deadlines for witness statement exchange by 1 week. Now, the one person that would be prejudicing would be us, because we would then have to try and get to grips with what we were being told within a week and draft witness statements in a week. And then again at W418, we wrote back again. And we can see at W418, in view of your difficulties, please again, could you sign the attached consent order, which provides for an extension of time? and just provide your, and then we said, could you provide your written confirmation by no later than 1st of April that you will provide a substantive response? Then we can get a consent order in and we can just get on with this. And then if we go to the next page, 419, for the avoidance of doubt, the extension of time for exchange of witness statements assumes that your client will provide a response to the requests by the 5th of April. And for the avoidance of doubt, our clients will take such action as is necessary to ensure that the date set for the PTR is not derailed. So there we are, yet another attempt. Then just came back correspondence saying that, criticising our approach. By then the deadline's approaching for witness statements, and it's, well, they're clearly not going to respond, as has been borne out by the intransigence during this application as well, and therefore we need to get this before a judge, before the registrar, and so that we can make sure that the matter stays on track. So any suggestion that we've been trying to derail the procedural timetable, it's simply incorrect. I don't know what else we could have done. We sought an expedited hearing. We had a directions hearing because the defendant basically said that they wanted to put the witness statements in first. That lost another few weeks. Now, my learned friend, in relation to confidential information, she was saying that we were asking for documents in relation to confidential information. We're actually asking for facts. What are the facts? What is it you're relying on? My learned friend talks about wholesale non-compliance in relation to disclosure. I'd suggest that's an inappropriate characterization. First of all, any non-compliance in the first instance was on the defendant's side. There has never been a finding that we have not disclosed deliberately.
I'm sorry, I must object to that. There has never been a finding that the defendant was non-compliant with disclosure. There's never been an application in relation to that. It's never been alleged. It's never been found. But I do object to that. My learned friend wasn't instructed at that phase, and that is simply wrong.
But I'm not saying, the point is, I'm not even going into whether the defendant has given disclosure. Or sufficient disclosure. I'm not going there. It's about the allegation that the claimants are somehow at fault with wholesale non-compliance.
That was found in Justice Giles's orders.
To say it was wholesale is simply incorrect. There were findings that we hadn't been specific enough as to what was in our custody, control, and possession, and in how we couch some of the statements. But in terms of the disclosure that was provided, there has never been a finding that we have not provided what we should have provided, that we are guilty of some wholesale concealment. So I must take exception to any suggestion in that regard. I'm just going to check with those instructing me to see if I've missed anything out. As regards the criticism about the way that the requests are structured, they're structured in entirely the normal way, which is by reference to the pleadings, paragraph by paragraph. And if my learned friend finds them repetitive, it's because of the way in which this has been pleaded. The amended defence and counterclaim, it's repetitive, it's full of non sequiturs, it mixes up concepts. Well, Madam Registrar, I'll leave you to look at the pleadings yourself personally. It's extremely difficult to follow, particularly when we're trying to understand a case against us. But the main point is that it was incumbent upon the defendant to give a line-by-line response in accordance with RDC 19.15, and they failed to do so. Even on the most basic of things, like the relevance of the CCL, it's just deliberate intransigence. And it's simply not consistent with the overriding objective. Unless I can assist you further, Madam Registrar.
Thank you, Ms. Stewart. I think at the end of the day, we've got a case that basically where Ms. Stewart, you have a particular style of working and the defendant has a particular style of working. I've made the comment before, and Ms. Hurst raised the same comment, that where it comes to the counterclaim, purely the counterclaim, it is up to the defendant to make proof of her counterclaim. And if she fails to make proof of her counterclaim, then it will fail. Obviously, you make the submission that if you do not prepare for the counterclaim properly, then it will obviously disadvantage your client. And I understand that and I hear that. So for that reason, I will hand down my decision now, which is that I will grant the request in part. And I'm going to walk you through what I'm granting and what I'm not granting, and the way that we'll do this. The way I'll grant the request is I will ask the parties to submit their witness statements by Thursday next week. So that's 1 week from today by 4 p.m. The defendant in particular must, within her witness statement, refer to certain aspects of the request and then provide a separate document in a table to say where she has dealt with the request within the witness statement. So the requests that I will allow are request number 3, request number 4, request number 11, request number 12, request number 13, request number 14, request number 17, and that's it. Now, with respect to the certain documents that have been sought by the claimants, I'm going to deal with these in 2 different ways. There are some documents that go to the counterclaim, and these are the documents that I suspect the defendant will produce anyway, exhibited to their witness statement, exhibited to her witness statement rather. There are other documents that ought to have been sought during the standard disclosure process. So the way I'll deal with these is as follows. So if we go to request number, just bear with me while I go to the front of my page. Request number 16. request number 18 and request number 19. With those requests, I will assume that permission to file a further Part 28 has been granted. So I will grant permission for that Part 19 application to be deemed a further Part 28 application. And with those three requests, the defendant is to reply using the Part 28 standard or the Part 28 form to the nature of those documents. So Ms. Hurst, your client still has the opportunity to say whether or not those documents are relevant and whether or not they ought to be produced. And Ms. Stewart, you will then have a right of response, and then we will make a decision on those three types of documents that I've just referred to. Now, with respect to other documents requested within the request, which is documents 21, 22, 23, for example.
Madam Registrar, we're not actually asking for documents there. We're asking for facts.
You are asking for facts, you're right, in 21. However, in 22, you ask for receipts, is that right?
No, again, it's facts.
Of such receipt by the shareholders, I see. But then 23, I mean,
Yeah, it's all facts.
you're essentially asking for facts in the context of documents, Ms. Stewart, because these facts cannot be provided without reference to certain spreadsheets, for example, and the like.
Well, no,
So,
they're just, I mean, for example, EBITDA is a number. Earn out sale proceeds.
but it's not a number that can be provided off the top of someone's head. It's a number that ought to be referred to in calculated spreadsheets. So technically, for them to provide those numbers to you, they would have to adduce certain spreadsheets to prove the accuracy of those figures given to you.
Well, no, EBITDA, it might be, for example, in accountants' reports, earn out sale proceeds. They'll be, you know, it's known. I mean, all we need to know are the facts. When, how much.
Madam Registrar, just to clarify, I think my submission on this was that the facts are in the documents that have already been provided.
Maybe my learned show me where, because I've spent hours poring over them and I can't find them.
You'll have it in the witness statement as we've
so.
consistently submitted. It'll be in the witness statement.
It's the whole basis of our case. How much, when, interest.
Okay, I'll tell you what, given that they are so easily referred to, Ms. Hurst, then I'll allow those as certain, I'll allow those within the requests I've just allowed. So these can be added to the list of requests that I have just mentioned. And I trust that the Court Associate is taking note of my orders. So 21, 22 and 23.
And that's in the table that you have ordered for us to, we serve the witness statement and then we will point out where those are dealt with.
Correct, yes. Now,
Understood.
yes, exactly. So these can be, given that they actually go towards the defence and not quite the counterclaim, they can be in a separate section, or you don't have to put them in the witness statement at all. If it's quite easy for you to simply refer to them in the table and say that we have referred to them in previous witness statements, then you are very free to do so, Ms. Hurst. It's completely up to you. But you are compelled to comply with requests 21, 22 and 23. So that's the extent of the request that I will allow. What I was going to say about other types of documents, which now is no longer relevant because there's no other types of documents which have been referred to within the request that I deem necessary for production. But in the event that those ought to have been produced in standard production, then I wasn't going to grant permission for production of those documents as yet. I was going to compel the claimants to file a separate application for permission to produce those documents. But that's no longer necessary, no longer relevant. In terms of the costs order, I'm happy to hear your submissions on the costs order. I suspect you'd have very long submissions to make. My thoughts that the costs ought to be in the case at this stage, and this is something that will probably come back to me in a detailed cost assessment, and depending on how the case went and the nature of the information provided, the assessor, the cost assessor, typically being myself, is then in a much better position to decide how costs go and whether costs ought to be rewarded or not. But in terms of the cost order now, I mean, Ms. Stewart, what's not working in your client's favour is that the request was filed quite late. I have heard your submissions, obviously, on the point that Mr. Krishna's firm was instructed at the last minute. So you can make the cost submissions now. Otherwise, I'm happy to reserve costs until I've had some time to think about the matter, and you're very free to make submissions as well, if that's what you'd like.
I will take instruction on that. Could I just ask a question? A lot of these requests that you have granted, and that many have been granted, are of course fundamental to what we're trying to, us trying to understand what the case is. Would it make sense, therefore, and I would suggest it would do, for the defendant to put in the witness statement first, and we can just cover our claim, which is, here are the settlement agreements, that can be our witness statement. In their witness statement, it's much more expansive, and it covers the responses to these requests, and then we can come back, rather than drafting something now that could be completely pointless.
Madam Registrar, I do strongly object to that. The directions have been given for simultaneous exchange. That's entirely standard. There's absolutely no reason why the parties shouldn't both be required to put their factual evidence in at the same time. The claimants don't need to tailor their evidence based on what the defendant is saying. If their case is as stark as they say it is, then they are able to articulate that case. They don't need to see what the claimant has to say about it. And I would remind the court that there is, of course, provision for reply evidence. And so the claimants will have an opportunity to respond to Ms. Benton's witness statement in that usual way. But I would say it would be wholly unusual to order sequential exchange of witness statements in this case. And I do strongly object to that.
But I'd suggest that it's unusual to say that actually these requests are required, and they go in a witness statement at the same time as exchange of witness statements. So it isn't a much cleaner way of doing it. Either the defendant goes first and answers these, many requests that Madam Registrar has found to be justified, and then we can respond, or we both can put in a witness statement at the same time, but we don't cover the defence and counterclaim in that witness statement.
I'm not quite convinced, Ms. Stewart, but good shot. I think I will at this stage order that costs be in the case, just because I think that, as I mentioned at the forefront, I think this is a question of form, and I think both parties could have made much stronger efforts to try and agree the way forward, rather than take it to this stage where approximately 3.5 months before trial, we're stuck at a crossroad where witness statements have not yet been exchanged and certain particulars have not yet been pleaded in expansion. So I think that I will order that costs be in the case, and this is a matter that I will come back to at the end of the proceedings, and we can hopefully flesh it out then. But I should say, just in passing, I'll mention this comment. I think that the claimants probably should have agreed to some extent to allow the defendants to submit their witness evidence before pressing forward so aggressively with a Part 19 request. I think that the Part 19 requests did have teeth, but I think that this is the issues raised within it is a matter of form over substance. So this is the reason why I'm not inclined to make a costs order in anyone's favour at this stage, and we'll wait to adjourn it until the end of the proceedings.
All I would say is that I had the delightful task of beginning to look at how to approach the witness statement. And all I could say is at this stage, in terms of this first round of witness statements, it will be necessarily very truncated. It has to be, because basic points have not been set out in the pleadings.
At least certainly with respect to the claim made by your client, Ms. Stewart, that's probably something that you can address in the first round of witness statements.
Of course.
And then, yeah, and the supplementary ones, I suspect, would be addressed, would address the counterclaim raised by the defendant.
That's exactly what I was suggesting. So we set out our claim, which is settlement agreements. Here we go. That's it. In that, and then we understand the defendant's case from their witness statement, and then we can respond to that.
I'm sorry, Madam Registrar, but I do object to that. Now, you know, a lot of emphasis, obviously, it's my learned friend's Part 19 request. Emphasis has been placed on our pleaded claim, on the defence and counterclaim, and you've been taken in detail through paragraph 33 of our defence and counterclaim. But can I remind you of the claimant's reply to the counterclaim and the defence of the counterclaim? And I showed you paragraphs of their reply, which simply says, this is denied and the defendant is put to proof. So actually, in terms of the pleaded case, there is no full pleading whatsoever from the claimants as to what their case is on the counterclaim. Now, we've got a sniff of it through the disclosure application. As I showed you, we went through the witness evidence, we've seen what they have to say about it. But their pleadings don't go through anything like the detail that our pleading does, what their response to what the defence is to the counterclaim. So I'm afraid I do strongly object to the idea that they reserve their position until reply evidence, and that we get, for the first time, a full explanation of what their defence to counterclaim is there. Now, of course, I haven't articulated those points fully before you today because it wasn't my application for a Part 19. And the reason there's no application for Part 19 from me is that it's always been our position that the parties would make clear their case in witness evidence by reference to the documents. But it is absolutely the opportunity now where the claimants must explain their case, because it's in no way properly pleaded in the reply and defence to counterclaim either. So I do, I'm afraid, insist that witness statements are simultaneously exchanged and that the claimants say what they have to say about.
Absolutely, and just to, yeah, and for the avoidance of doubt, just to make it very, very clear, I was not in any way suggesting that we delay witness statements on the part of the claimants. Both parties should and have the duty, as counsel are both aware, they've got the duty to completely put all their cards on the table in this first round of witness statements. To the extent that certain information is not made available to you until you have received and have been served with the witness statement from the other side, then you may raise your responses in the supplementary witness statements. That is not to say that you ought to you both need to make your positions crystal clear. Put all of your cards on the table in this first round of witness statements and the responsive. And on that note, do we have a time frame for the exchange of responsive statements?
We did, Madam Registrar, but that is likely to need to be adjusted, given that it was in the 9th of March order, and obviously you suspended the first round of witness evidence. So I suspect there'll be a knock-on effect for all of the other procedural steps. So we might need to address timetabling for that.
I think we need to, yeah. Because if we've got witness statements due next Thursday, the 2nd of June by 4 p.m, including a table essentially dealing with the requests that I've just granted. So they're to be filed and served simultaneously, and obviously the defendant has that extra.
I'm sorry, Madam Registrar, I missed the date. Did you say the 2nd of June?
2nd of June.
Thank you. I apologise.
4 p.m. Yes, please. Thank you. And the defendant's obviously got the extra obligation of filing the table, cross-referencing compliance with the requests alongside its witness statements. How long do the parties need to file responsive evidence, and how long did we grant last time for the responsive statements? I suspect it would have been 2 weeks, but I could be wrong.
2 weeks, I think. My draft. Let's have a look.
The previously agreed case management order is at tab 12, beginning on W91. So it had what looks like about a month or 4 weeks. It was supposed to be 4 p.m. on the 6th of April for witness statements and first witness statements, and then 4 p.m. on the 11th of May for second witness statements.
I did provide a draft order along with the skeleton argument, which shows, I think, that
I think
should be enough time.
To be honest, I think that given the lateness of the Part 19 being heard, and in light of the fact that the trial is 3.5 months away, I don't think we can afford a month for responsive statements, particularly given that expert reports are intended to be filed and served as well. So I suggest 2 weeks. This means that your legal teams will be quite busy preparing supplementary evidence. But is 2 weeks sufficient? I'm happy to grant an extra few days, say 2.5 weeks, if that's a bit more convenient.
I mean, one option, perhaps, Madam Registrar, and I know it's not ideal, but if a month is more realistic for reply, it's possible that we could do that sort of contemporaneously with expert reports. As I think, my learned friend will correct me, but I think the sort of scope of expert evidence is quite narrow and it's probably quite discrete. So it might be possible to have a timetable where we have a month gap for reply, and then perhaps the expert reports follow on in short order, rather than truncating that first stage. But that would be my suggestion.
To work because I don't think we can have contemporaneous expert reports. We're going to need to have probably the experts are going to need some time to look at the witness statement. I'd be very uneasy about that. I would suggest I had in my draft order, if we had the first lot of witness statements on the 17th of June, and this just shows, I mean, we can have it before then, of course, and I know, Madam Registrar, you'd like to. If we then had 2 weeks after that, expert reports 2 weeks after that, supplemental expert reports 2 weeks after that, the supplemental expert reports would have still come in just before the pre-trial review. I don't know if you have my draft order there. So
I don't have that document, I'm afraid.
If someone could please send Ms. Hurst a copy of that document, but I think 17th is far too late, Ms. Stewart.
Yeah. No. The only other reason is, as you may be aware, Madam Registrar, I'm actually in trial all of next week.
Okay.
So, and that is a very full trial. So, it would be good.
I understand that. I can give you, I think with the date of the 2nd, which is when which is when the witness evidence, the first round, is due to be exchanged, I think we have to stick to the 2nd on the basis that the request was filed just before the time period for the exchange of evidence. So I think it was filed the day before is what I'm hearing. If not,
no, the requests were filed over
The
2 weeks
the
before.
requests were just under 2 weeks before the deadline, and the application was
under
filed
2
the day
weeks.
before.
Okay, all right. So if we pick up that time period, if you need a bit more time, Ms. Stewart, do you need a little bit more time for the filing of?
For the first round, I just
For the
don't want.
first round? Okay.
I don't know what Lord Glennie is going to order in terms of closing submissions. So
Okay.
on the trial.
If we say the 7th of June, which is a Tuesday.
Yeah,
which is the simultaneous exchange of the first round of evidence, as well as the defendant's table, complying with the Part 19 request and the Part 19 order, which will be issued by the court shortly. So that's on the 7th of June. And if we then say the 24th of June for responsive statements, 4 p.m. on the 24th of June for responsive statements.
yeah.
And then we give the experts, say, is 2 weeks sufficient for the experts to work on their reports, or is that a short window?
I think I personally think 2 weeks should be enough.
Yeah, I think that ought to be achievable. It is short, but they don't have a huge mandate. So
okay, so the 8th.
We ought to do that.
Fantastic. So the 8th of July is when the first round of expert reports ought to be simultaneously exchanged and filed. And then if we give the parties, I've lost the case management order now, but if the parties have, sorry, if the experts have
supplemental expert reports would be then
2 weeks after that date, or should it be less even? I think even a little bit.
I mean, we did previously have a month for supplemental reports. So
okay.
But again, we can obviously truncate that, but I'd be nervous of truncating it beyond 2 weeks, just because we don't actually currently necessarily know their availability.
That's fine. So let's say the 27th of July, which is a Wednesday. So that's 2.5 weeks. Is that sufficient? Or if you want, we can even take it up to the 29th of July, because I think by that date we'll be well back on track.
I think
we have the PTR on the 29th. So it might
okay. The PTR is on the 29th. Okay, and I know that
it may make sense, yeah, to have the experts at least to have them provisionally being exchanged before then, so that we can have a sort of update, as it were, on the 29th.
Fantastic. Okay, so sorry, I'm going to actually push it a day before, so the 26th of July. So that gives them a little bit over 2 weeks.
Mm-hmm.
And then you've got 3 days to read through those supplemental reports in time for the PTR on the 29th.
Yeah.
Okay, and then the timetable's back on. Could I please ask council to agree? I know this is a far cry, but I'm really hoping that my orders can be reflected in an agreed order, which the parties can put their heads together, which council can put their heads together and draft. If you can send that to the court today, and the court will seal that and issue it first thing tomorrow morning.
We can certainly work on that today.
Thank you very much.
Can I clarify? Sorry, Ms. Stewart, do you want to have carriage of that, or do you want me to have carriage of that in the first instance?
I'm happy for you to give it a shot in the first instance.
No problem. I will crack on with that.
Thank you very much, Ms. Hurst. Much appreciated. Thank you.
Thank you very much. Can I just flag that we have 2 days for trial? I'm not wholly persuaded that that's going to be enough.
Okay, so trial is listed for September, but can you please remind me which dates it's fixed for?
The 22nd and the 23rd.
Okay, so Thursday, Friday. Let me see. I don't know if council's available on the 21st, but it would make sense that we don't carry on through the weekends. If it's 21st, 22nd, 23rd, I can check the judge's availability as soon as possible.
From my perspective, I could make the 21st. I am out of action following this trial
Okay.
from the 23rd, so going the other way poses me difficulties, but I
Okay.
can certainly do an extra day earlier in the week.
Okay, fantastic. So if the court associate again would check the judge's diary for the 21st of September. Ms. Stewart, are you available on the 21st?
Yes, yeah.
Good. And that way, if we finish early before the Friday, then that's a nice welcome surprise for the weekend. Sorry, if we finish early on the Friday, not finish before the Friday, because we need to finish before the Friday, clearly. So 21st, 22nd and 23rd, the court will check the judge's diary for the 21st and revert as soon as possible.
Thank you. Can I just ask or note in respect of that, that it's not something that we've sort of given detailed thought to for today's hearing, but perhaps if the time is available, could we reserve that date, but assess at the PTR perhaps what an appropriate timetable would look like and whether we do need the 3 days? Because I have to confess it's not something that we've revisited in a while.
Of course.
But I think the suggestion to see if the time is there is obviously makes sense.
I think it makes sense to reserve it, yes. And then at the PTR, I think parties will be well equipped to find out, or rather to let the judge know how long they expect their submissions and examinations will take. So, and the judge will be in a better position to then give you some guidance on whether he's inclined to sit for 3 days or not.
Yeah.
Okay.
And there's just one other point on the timetable that I should point out. As far as I'm aware, we have a progress monitoring date reserved in the timetable on the 22nd of July. I don't know if that's actually in the court's diary, but given what we've just run through as a revised timetable, it doesn't seem to me that that's going to pose much utility if we're going to be gathering on the 29th anyway.
No.
For the PTR.
Essentially, today's hearing is almost like a progress monitoring hearing, and then you've got the pre-trial on the 29th of July. So that date would be redundant, and you can vacate that in your diary.
Right.
Thank you. I just wanted to make clear that that's vacated for the court, really, so that we haven't reserved court time that we're not going to use.
I think it is, again, another question for the court associate who's listening in. If you wouldn't mind checking the 22nd of July to see if there's anything listed for CFI 005. I don't think there is.
Okay, perfect.
Yeah, thank you. Thank you, Ms. Hurst. Well, that took almost 4 hours. Have a lovely day. And I look forward to receiving the draft order by, the end of today, your time, so long as it's received before tomorrow morning is perfectly fine with me. So we can have that issued and sealed as soon as possible. Thank you very much.
Thank you, Madam Registrar. Thank you for sitting so much later than had been indicated. We are very grateful.
That's okay. Thank you very much. Thank you. Bye-bye.
Thanks. Bye.